interpreter's office.
Good morning. This is Dalia Romero, Spanish interpreter on the line, already sworn in today.
If you could please connect to the headset.
Yes, one moment, Your Honor, please.
Sí. Yes.
You can hear the interpreter, Your Honor.
Please tell me your name.
Israel Garcia.
Israel Garcia.
Sir, you're here charged with the open container of an alcoholic beverage. Was there an offer?
Yes, Your Honor. State made an offer of a withhold adjudication, credit time served.
I did give him the Spanish plea form as well, Your Honor, to review, and we went over the form in the back. He would like to accept the same offer.
All right, Mr. Garcia, can I please have you raise your right hand to be sworn?
Do you swear to, do you
Yeah.
swear or affirm the testimony about to give the truth, the whole truth, and that's what's true?
Sí.
Yes,
All right, Mr. Garcia, you heard what Ms. George just said as a friend of the court. Is that what you want to do here today?
Sí.
yes,
You understand the rights you're giving up by entering a plea of guilty or no contest?
Okay.
okay,
You understand the rights you're giving up?
Correcto. Yes.
correct, yes,
All right, do you have any questions for me about the rights you're giving up?
No.
no,
You understand that if you're not a U.S. citizen, this plea could subject you to deportation?
Correcto. Yes.
correct, yes.
All right, sir, at this time, how do you wish to plead to the charge of open container of an alcoholic beverage?
No contest.
No contact.
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs, and I'll give you a year to pay those. You have 30 days to appeal in writing.
I didn't have the case number. I couldn't write it.
I don't either. It's not on the sheet.
Okay.
What's his last name?
Garcia Vasquez.
22 MO 826.
Oh,
Good luck,
Your
sir.
Honor.
Thank you.
We have one more Spanish case.
Your
No?
Honor, only one.
All right, that's all we have for the interpreter at this time.
Thank you, Your Honor. Have a good afternoon.
You as well.
Thank you.
Please tell me your name.
Jacqueline Ann Kutani.
All right, ma'am, you're here, it looks like, for several failures to appear.
Well, ma'am, I was in another facility May
Don't
22nd.
talk.
Oh, okay. Let me tell you why you're here today. This is just a first appearance for me to tell you the reason that you were arrested, what your charges are. If you think you have some defenses, like for instance, you didn't willfully fail to appear, but you were being held in a facility, that's a definite defense to failure to appear. But you can't raise it today because I can't change a capias. So what'll happen is you're entitled to have an attorney represent you. If you can't afford an attorney, I can consider appointing one. And then what you'll do is your attorney will file a motion in front of your trial judge. But that's why she said don't talk about the facts, because everything you say is being recorded and can be used against you later.
Am I allowed to talk now? Okay. An attorney was appointed for me and a judge. When
You have an attorney?
I submitted a plea of not guilty. The reason I failed to appear was I was in Orlando Health Behavioral Hospital from
All right.
May 3rd until May 29th.
So in case number 22MM3425, the capias was issued for failing to appear for arraignment on charges of violation of a domestic violence injunction order. The judge set the bond at $1,000 on each count. Does she have a PD already?
I don't
she
see one for
qualify?
it, Your Honor.
All right, ma'am, I'm going to appoint the public defender's office to represent you.
I don't
Well, we
have
got to
the
go one at a
$50.
time.
I've
You
been-
have several cases.
Yeah, I've been overdrawn at Atlanta Credit Union for about 10 days now. It's July 5th, actually.
All right, so in 22 MM 3426, a capias was issued for your arrest for failing to appear again on a violation of a domestic violence injunction order. The judge set that bond at $2,000.
Ma'am, I did appear April 6th at the courthouse. I went up and
All right,
submitted
just give me a
plea.
minute, ma'am. You have several more cases. I need to address them all.
I don't have transportation. I never have since Labor Day 2005. I was crashed into.
I understand. All right, in 22
I've been
MM.
tortured in your. I was tortured in. Oh,
At the jail?
at the hospital. There's a black mold in the shower stall.
Ma'am, I can't hear you.
There was black mold in the shower stall. I was forcibly injected 6 times with Regeneron drugs. Depo caused my lower lip to blister and then bleed. It's an antipsychotic drug. The forced administration,
Your Honor, I
I
will,
was held down.
I will
with
waive-
6 black uniform security guards.
oh,
Okay.
6 times forced injections.
All right, here's what I'm going to do. At this time, I'm going to appoint the public defender's office to represent you in each of your cases.
I think.
Ma'am, each of these cases, a capias was issued for failing to appear on the same or similar charges. It's violation of a domestic violence injunction. I'm going to ask Ms. George, if you would please leave a note for your office. I'm asking the public defender's office if they can get someone to see you right away and maybe an evaluation.
Ma'am, do
And-
you happen to notice the date of the first violation injunction was filed? November 1st, isn't it?
I don't have that information. What I have is the date that it alleges on the capias you failed to appear for court. Because those are capiases signed by other judges, I cannot change it. So your attorney is gonna have to file a motion. Now, it looks like, give me a moment, it looks like in each of your cases, the judge who appeared issued a bond. So you're not being held at no bond. However, you do have several $1,000 and $2,000 bonds. So your attorney is gonna have to file a motion in front of your trial judge to get that changed. But I'm asking them to come see you right away. Do you understand, ma'am?
I am kidney disease.
And we'll see if we can get you some help right away.
I don't have a car. Can't make bond.
They're gonna file a motion on your behalf in front of the trial judge, all right?
This is just an arraignment,
Right, it's a first appearance.
but I,
So because I can't change the capias, I can't lower your bond. But they can ask the trial judge to do that, so that's what they're going to do.
And I've already emailed someone downtown, so we're working on it.
All right, so they're already working on it, ma'am.
it was me that was assaulted by Orange County Sheriff's Officer Sir Matthew.
You might have been, but I can't change that at this point. That's something you have to raise, that's what I'm telling you, you have to raise it at a different time. Today, I can't make that
You
change.
can't raise it. You can't file charges against the Orange County Sheriff's Officer.
You can, and your attorney can walk you through that. All right, good luck, ma'am. Ms. George, for the record, on each of those cases, I didn't call out each one. I think there's some mental health issues. I didn't see that it would help if I did that. I think the longer I kept her here talking about it, the worse it got.
Yes, Your Honor.
But effectively, we're kind of waiving her appearance on those because I didn't address each one individually.
Yes, Your Honor, I will
Right,
waive.
but I'm staying the bonds, I'm not changing anything. I just decided to stop at addressing each case. I think that was making it worse.
Yes.
My name is Brian Grajales.
22 CT 3849, You're here for an arraignment on a charge of driving while license suspended or revoked.
Your Honor, state did convey an offer of an adjudication credit time served. From my knowledge, I believe he has at least one prior. It was a withhold from 2021, so he will not be HTO'd.
And he would like to accept the state's offer and enter a plea of no contest.
Raise your right hand, sir.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you heard what Ms. George just said. Is that what you want to do here today?
Yes, ma'am.
All right, you can put your hand down. You understand the rights you're giving up if you enter a plea of guilty or no contest?
Yes, ma'am.
Further, you understand that driving while license suspended is what we call an enhanceable offense. And what that means is after the third conviction, the state can file this same charge as a felony. You understand that?
Yes, ma'am.
And you have at least one prior.
Yes, ma'am.
So the next one, the state could file it as a felony, possibly. I don't know that they will, but I'm telling you they can.
Yes,
You
ma'am.
understand that?
Yes, ma'am.
You understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
If you're on probation anywhere, this could violate your probation?
Yes, ma'am.
All right, at this time, how do you wish to plead to the charge of driving while license suspended or canceled or revoked with knowledge?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 6 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay that.
And Your Honor, could it be a year upon release? He has multiple other charges.
Yes, a year from the date of release. Good luck. You have 30 days to appeal in writing. Thank you.
I'm Mr. Sebastian.
22 CT 6815. You're here charged with driving while license canceled, suspended, or revoked with knowledge.
State conveyed an offer of an adjudication credit time served.
And Mr. Mambas would like to accept and enter a plea of no contest.
Please raise your right hand.
Plea. Mm-hmm.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir, you understand the rights you're giving up by entering a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about these rights?
Your Honor.
Is that your signature?
Yes, ma'am.
All right, you understand that if you're on probation anywhere, this plea could violate that probation?
Yes.
And if you're not a U.S. citizen, you could be deported?
I don't know how that's gonna affect. Because it may hurt. I'm sorry, Your Honor, he's on parole. It's just, if you. He understands, Your Honor. He still wants to resolve it.
Okay. And if you're not a U.S. citizen, you could be deported? You understand that?
I understand.
You understand that your third or subsequent offense of driving while license suspended, canceled, or revoked, the state can file as a felony?
Yes, ma'am.
This could count toward that. I want to make sure you understand that. Do you have any questions for me about the rights you're giving up?
No, ma'am.
At this time, how do you wish to plead to the charge of driving while license canceled, suspended, or revoked with knowledge?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 3 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay that from the date of arrest, and they'll have to fingerprint you. Good luck, sir. You have 30 days to appeal in writing.
All right, thank you.
Yes, sir.
Your Honor, Natisha Clark is medical.
I'm going to appoint your office, Ms. George.
I will waive and enter a plea of not guilty, Your Honor.
Pretrial would be in Division 80, August 22nd at 9 o'clock in courtroom 9C.
Caldwell bonded or pretrial.
Hello, Chubby.
22 MM 4858, you're here charged with resisting an officer without violence. And 22 MM 4859, you're here charged with trespassing on property after warning. Ms. George, did you wish to be heard?
Your Honor, the offer from the state was an adjudication of guilt, credit time served, no return to 1112 North Cimarron Boulevard, and court costs. Mr. Chavez would like to accept and enter a plea of no contest.
I might accept that, but he's out on bond in 2 cases. I might still be inclined to revoke that.
Yes, Your Honor. I would ask, since he's resolving the new law, that you take no action on the out on bond, given that they're unrelated, Your Honor.
What's
And I will-
state? Oh, sorry. I'm sorry, Ms. George.
I'm gonna just talk to him about that while you ask the state.
Your Honor, given they're driving related, state has no objection to taking no action. However, understanding that it's within your discretion. His last failure to appear was 2007. So state doesn't share many concerns regarding him showing back up to court to deal with those 2 cases. And they do appear to be a little bit older cases from 2021. And doesn't appear he's had any issues appearing for court on them to date. So state would request no action if he otherwise pleads to the new laws today.
All right, thank you. I'll do that. Please raise your right hand, sir.
You swear or affirm that the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Chavez, you understand the rights you're giving up by entering a plea of guilty or no contest?
Yes.
Do you have any questions for me about those rights?
No.
You understand that if you're not a U.S. citizen, this plea could subject you to deportation?
Yes, ma'am.
You understand that if you're on probation anywhere, this plea could violate that probation?
Yes, ma'am.
At this time, how do you wish to plead to the charges of resisting an officer without violence and trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
2 days.
2 days you've been in custody. I have to order that you pay court costs and that you not return to 1112 North Cimarron Boulevard. I'll give you a year to pay those court costs from the date of your release. I'll take no action on the out on bond cases. Good luck. You have 30 days to appeal in writing.
Jeremy Austin Elder.
22 MM 4857, you're here charged with trespass and resisting an officer without violence.
Your Honor, state didn't convey an offer at this time.
Has not?
No.
All right. Are you going to tell me if they don't qualify? So if you don't tell me, I assume they will. All right, Mr. Elder, I'm going to appoint the Public Defender's Office to represent you.
And I don't see much of a criminal history. I'm just checking to see if he would qualify for pretrial release.
Bond or.
Okay, could we do bond or pretrial release, given he doesn't have much of a history? They have to interview him. He hasn't been interviewed.
What says the state?
State has no objection.
All right, sir, at this time, I'll place you on pretrial release with conditions. You cannot return to the scene. You can have no contact with any victim or witness. Any other conditions the state would request?
No, Your Honor.
Good luck, sir.
Such a straight PTR?
Yes.
Oh, Your Honor, I do believe he was getting evicted from that location. I don't know if a one-time return is,
Does he need a one-time return?
We need a one-time return.
I'll give him one-time return with law enforcement to gather belongings. Yes, sir.
Your Honor, Gonzalez, Madam, is behavior.
22 MM 4864. I'm going to appoint the public defender's office.
I will waive the appearance, Your Honor.
All right, there is probable cause. Bond is $500 on count one, $250 on count two. No return, no contact with any victim or witness, no weapons, firearms, or ammunition
At 250?
on count two. Yes, ma'am.
What was the reason, behavior?
Yes.
Luz Rosada.
22 MM 304, you're here charged with cruelty to animals. I'm going to appoint the public defender's office to represent you.
There's no offer at this time, Your Honor.
All right. There is probable cause. Your bond is $1,000. You can have no contact with any witness in this case, and you can have no contact with the animals. Good luck.
Your Honor, Odom was behavior also.
22 MM 4846. I'm going to appoint your office in that one as well, Ms. George.
Your Honor, could we see if he could come tomorrow? He does have an offer to resolve his case.
I'm all right with that. Let's try him tomorrow.
Mary Arthur Porter.
All right, sir, you're here in 22 MM 4865, charged with resisting an officer without violence.
Your Honor, state did convey an offer to Mr. Protter of an adjudication credit time served.
And, Mr. right here. Porter would like to accept and enter a plea of no contest.
What? Not yet.
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I affirm.
All right, sir. You had the opportunity to discuss with the attorney the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
You have any questions for me about them?
I just go home today, correct?
Right,
Okay.
but I want to make sure you understand the rights you're giving up before we do that.
Yes, ma'am.
Is that your signature?
Yes, ma'am.
You understand that if you're on probation anywhere, this plea could violate that probation?
Yes, ma'am.
And if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
All right, at this time, how do you wish to plead to the charge of resisting an officer without violence?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. I have to order that you pay court costs. I'll give you a year to pay those. You have 30 days to appeal in writing, and as long as there's nothing else holding you, you'll be released today.
Okay. Thank you, ma'am.
Yes, sir. Have a good day.
You too. God bless.
You too.
O.Z. Washington?
Mr. Washington, you're here in 22 MM 4863, charged with trespass on property after warning.
Your Honor, state did convey an offer to Mr. Washington of an adjudication of guilt, credit time served, and no return to the Homewood Suites at 5893 American Way.
And, Mr. Washington would like to accept the state's offer and enter a plea of no contest, Your Honor.
Raise your right hand, please. You have to, yeah.
Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Hold on, something just happened to my computer. Oh, no. Hold on a minute. I don't know what happened. It's never happened before, so give me 1 second. Ah, we got it. All right, sir. You understand the rights that you're giving up by entering a plea of guilty or no contest today?
I do.
Is that your signature? Do you have any questions for me about these rights? You understand that if you're not a U.S. citizen and you enter a plea of guilty or no contest, you could be deported?
I do.
And if you're on probation anywhere, this plea could violate that probation? All right, sir, at this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you spent in custody. I have to order that you pay court costs. I'll give you a year to pay those, and that you not return to the address the prosecutor gave us. Do you have that again? It's the Homewood Suites at,
Homeward Suites at 5893 American Way.
you understand you can't go back there, sir?
Understand.
All right, good luck. You have 30 days to appeal in writing.
Douglas, ask you.
Give me 1 moment. Sir, you're here in 22 MM 4836, charged with battery. I'm going to appoint the Public Defender's Office to represent you. Ms. George, did you wish to be heard?
Thank you.
No, Your Honor. I believe this was, maybe I'm looking at the,
Is it non-playable?
yeah, no, I thought it was a warrant.
It's not, because it's a battery. I just didn't know if you want to be heard on probable cause.
No, Your Honor.
There is probable cause, but in case, you were still standing there, so I wasn't sure.
Oh,
There is probable cause, sir. I'll set your bond at $500 with special conditions. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. Are there any other conditions the state would request?
No, Your Honor, just anything that's on the warrant.
I don't have it up because my computer is doing something weird. All right. Good luck, sir.
Thank you.
I don't know what Odyssey is doing, but it keeps giving me this weird error. So I wrote PC, but that's all I can.
Charlene Parks.
All right, Ms. Parks, you're here in 22 MM 4057. Let's see if this one opens. Here we go. All right, now it's opening. Capias was issued for your arrest for failing to appear for court on a charge of prostitution. The bond authorized on that is $2,000. I'll appoint the Public Defender's Office to represent you. Good luck, ma'am. Stay in touch with your lawyer.
That's it. You can pay the bond. That's it. It's 200, right? Just take the paper.
That's it.
William Demetrius Tynes.
Good morning, Mr. Tynes. You're here in 22 MM 4736 because a warrant was issued for your arrest, charging you with battery. Another judge has already found probable cause. Your bond will be $500 with special conditions. You can have no contact with the victim or any witness in this case. You can't possess a weapon of any kind, firearm, or ammunition, and I'll appoint the Public Defender's Office to represent you.
Thanks.
Good luck, sir.
Your Honor, Tyson was behavior.
22 MM 2438. It looks like your office already represents her. It's a failure to appear.
yes, Your Honor, I will waive the appearance.
All right, I'll stay the bond.
Stephen Anthony Garrison.
Sir, you're here in 22 MO 827, charged with sale or consumption of an alcoholic beverage where restricted.
Your Honor, state did convey an offer to Mr. Garrison of an adjudication of guilt, credit time served.
And Mr. Garrison would like to accept. and enter a plea of no contest, Your Honor. He does have some out on bond cases. In exchange for the plea, I would ask that you take no action. Can't resolve the 2021 MO 1384 AO because the agreement was that once he pleads to the felony, that they would drop the second charge, which is why we still have it open. So they're working on setting up a plea for his out on bond right now.
All right, let me ask, Ms. Fleming, what's the reason for the adjudication? I thought in the MOs, you usually ask the court to withhold.
Your Honor, there's a new state or a new city of prosecutor that gave us discretion to withhold or adjudicate. And given his history of other alcohol offenses, he's out on bond for an alcohol offense and other drug offenses, state believed it was reasonable.
All right. Mr. Garrison, please raise your right hand.
Do you swear from the testimony you're about to give, share with the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. You can put your hand down now, sir. Thank you. Sir, you heard what the attorney said. Is that what you want to do here today on this case?
Yes, ma'am.
Do you understand the rights that you'll be giving up if you enter a plea of guilty or no contest?
Yes, ma'am.
You have any questions for me about those rights?
No, ma'am.
Is this your signature?
Yes, ma'am.
You understand that if you're on probation anywhere, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
All right, at this time, Mr. Garrison, how do you wish to plead
No contest.
it's basically like open container, but it's sale and consumption of alcohol where restricted. All right, I'll accept your no contest plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you've been in custody. Sir, I have to order that you pay court costs. Mr. Garrison, do you have a place to live?
Yeah, yes, ma'am.
Do you have a job?
Yes, I work at the Tim Sir pay seller.
All right, I'll give you a year to pay it then.
Okay, yes,
Good
ma'am.
luck, sir. You have 30 days to appeal in writing.
Yes, ma'am.
No action. Thank you for reminding me. What? Yeah, just the one.
Adrian Clay.
Ms. Clay, you're here in 19 CT 1908 because a capias was issued for your arrest for failing to appear on a charge of driving under the influence. Your bond authorized is $2,500. I'll appoint the Office of the Public Defender to represent you. Good luck, ma'am. All right, give me one moment. '22 CT 4034. It's leaving the scene of a crash with property damage. I'll appoint your office, Ms. George.
I will waive the appearance, Your Honor.
All right, there is probable cause. His bond will be $2,000. No contact with any victim or witness in the case.
Joseph Simons.
21 CT 7575. You're here because a capias was issued for your arrest for failing to appear on a charge of driving while license suspended. There is no bond authorized on that capias.
Your Honor, state did convey an offer to Mr. Simmons of an adjudication of guilt, credit time served.
I have a moment, only because when I went back there, he was still not brought up.
That's fine. But no.
And Your Honor, he would like to accept the state's offer and enter a plea of no contest.
Raise your right hand.
Do you swear or affirm that the testimony you're about to give, share with the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir. You had the opportunity to discuss with an attorney the rights you'd be giving up if you enter a plea of no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them?
No, ma'am.
You understand if you're not a U.S. citizen, you could be deported?
Yes, ma'am.
And if you're on probation anywhere, this plea could violate that probation?
Yes, ma'am.
And driving while license suspended, canceled, or revoked, at the third time, the state can file that as a felony. You understand that?
Yes, ma'am.
All right, understanding all of these rights, how do you wish to plead to the charge of driving while license canceled, suspended, or revoked with knowledge?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days you spent in custody. I have to order that you pay court costs, and I'll give you a year to pay those.
Thank you.
Good luck.
I'll be released today.
Unless there's anything else holding you. But not on this, you will be.
Thank you so much.
Yes, sir.
Your Honor, Jorge Alejandro.
Sir, you're here in 21 CF 15689, charged with grand theft, greater than $750, less than $5,000. And information has already been filed by the state. The bond is $2,500. You can have no contact with the victim or any witness. And I'll appoint the public defender's office to represent you.
Your Honor, state would also ask for no contact with the co-defendant.
And no contact with the co-defendant.
Not today. You don't see us, so you gotta go downtown and see. You're gonna have to call the attorney so they can-
Good luck.
Antoine Jean Demers, not guilty.
Thank you, sir. You're here in 22 CF 8431, charged with kidnapping, false imprisonment, assault on a law enforcement officer, battery, and resisting an officer without violence. Sir, do you wish to be represented by an attorney?
No, ma'am, because all of it is not true. I just plead not guilty.
All right, but even if you think it's not true, even if you believe it's not true, that doesn't mean you don't want a lawyer to represent you. So a lawyer is there to represent you and help protect all the rights that you have. You have a bunch of constitutional rights, and an attorney can help protect those rights. You don't want an attorney to represent you?
No,
All right. Mr. Antoine, have you ever been diagnosed with any mental health illnesses?
I'm dying of schizophrenic, mental illness, bipolar disease. Schizophrenic,
I see.
bipolar, I'm dying.
When is the last time, are you on medication for that?
Yes, I have medication. I also take an Abilify injection every month, and it expired.
All right. Then, Mr. Antoine, here's what I would like to do for you today. I would like to appoint the public defender's office to represent you provisionally. Later, if you decide you don't want them, you can always tell the judge that, and whoever your judge is can remove them. But at least one of these charges is it's a felony punishable by life in prison. So because you've told me, and I appreciate that you were honest about your mental health history, I want to make sure today that we have someone who is making sure that your constitutional rights are protected. But like I said, you can fire them at any point, okay? All right, so provisionally, I'm appointing your office, Ms. George.
Yes, Your Honor.
Did you wish to be heard on probable cause?
No, the only probable cause challenge, Your Honor, that I was gonna make was as to the kidnapping. Only because he grabbed her and she moved, but there was no, removal to another location. It was all at the same place on a fence, Your Honor. There may be enough for PC, Your Honor, for today's purpose. I just don't believe the state is gonna be able to sustain a conviction for kidnapping. False imprisonment for sure, but not the kidnapping, Your Honor.
I agree. That was my concern. That's why I wanted to hear from you on that. I did review the probable cause affidavit, and that was my one question. Ms. Fleming?
Your Honor, I believe there's enough for PC. For the jury instruction, the defendant has to forcibly, secretly, or by threat, which in this case I believe would be forcibly, as it was against the victim's will, confined, abduct, or imprison. Here, I believe it would be he imprisoned her against her will. 2, he had no lawful authority to do so. He was not acting in any other kind of capacity, and he had no express consent from the victim. And 3, acted with the intent to interfere with the performance of a governmental or political function, which is in this case, inflict bodily harm or terrorize another person, facilitate the commission of another felony, or hold the victim for ransom. State would argue that it was to inflict harm upon or to terrorize. I believe there's enough for PC. However, state has no objection to you setting a bond, but would ask that you revoke his out on bonds, as he's out on bond for a battery. That just occurred June 25th, so approximately a month ago. So state has no objection to a high bond on 1, given it is a first-degree felony that's punishable by life. However, understanding that the facts don't completely lend themselves to a kidnapping as we generally see, but would ask that you revoke his out on bond if you are inclined to set bond on count 1, finding PC.
And my only argument as to the battery, Your Honor, is that he was released on a 33-day motion. No information has been filed to date in the battery. I'm not sure. I was just looking at the resisting, but I know as to the battery, we're appointed and no information has been filed.
The resisting's been filed. It was from, the arrest was December of 2021. And it's been KPS 1, 2, at least twice, maybe 3 times.
Wait, but there was an information filed?
Yes, back a while ago, back in February.
All right, here's what I'm going to do. And Mr. Antoine, just so you understand, count 1 is a kidnapping charge that's punishable by life in prison. That's the maximum. But based on your attorney's arguments today, you're not entitled to bond on that charge, but based on your attorney's arguments, I'm going to give you a bond on that charge. So I just want you to understand that it definitely benefited you today for me to appoint an attorney to represent you, at least for the time being. All right, so your bond on count 1 will be $25,000. Count 2 will be $5,000. Count 3 will be $1,000. Count 4, $500. Count 5, $500. With special conditions, you can have no contact with the victim in this case. Do you understand what no contact means? You can't possess a weapon of any kind, a firearm or ammunition. This was outside. Was it outside a business?
I believe it was just Pine Street and Garland. I don't believe there was any particular
Like they were just walking
location. I believe she was just walking.
Do you live near where this took place, Pine Street and Garland Avenue?
I'm homeless. I stay on the street. I sleep on certain variations on Terry Avenue. That's all.
Okay.
Stay like close to the homeless shelters.
Okay, then I'm not gonna say anything about returning to that area, just that you can't have any contact with the victim and you can't possess a weapon. I will, however, revoke his bond on both of his out on bond cases, so you're gonna have to file a motion, Ms. George.
I think he has, we're appointed on the battery, just not the resisting. I think it's Gary Swartz.
RCC.
Okay.
Okay.
All right. All right, Mr. Antoine, stay in touch with your attorney, okay? Good luck.
How you doing? Roderick Baker.
Mr. Baker, you're here in 22 CF 8425, charged with possession of cocaine with intent to distribute. I'm going to appoint the public defender's office to represent you. Did you wish to be heard, counselor?
Not as the PC, Your Honor. As far as his out on bond goes, I'm in 2022 CF 5488 AO, Your Honor. No information has been filed. It looks like he was arrested back in May, and to date, no information has been filed. On the driving while license suspended, it has been filed. However, given that they're unrelated, I would ask that you take no action.
All right, what says the state?
Your Honor, state will leave it within your discretion.
All right, sir, there is probable cause at this time. Your bond will be $5,000. You can't possess or consume any controlled substance without a valid prescription. You'll be subject to random drug screens while out. You also can't have contact with any known drug dealers.
And, Your Honor, as to the out on bond, also, my argument is that they barely made PC from my point of view as to the intent to distribute. So I just ask that you also consider that if you read which I know you did, read the affidavit.
I did. That's
so I
why I
just
asked if you wanted to be heard.
Yes, Your Honor.
I had the same thoughts. It's barely there.
Yes, Your Honor.
PC. All right. I'll take no action on your out-of bond. Good luck, sir.
Excuse me.
Keith Anthony Brown.
All right, Mr. Brown, you're here in 22 CF 8405, charged with possession of cocaine and soliciting funds without a permit.
Yeah.
I'm going to appoint the public defender's office to represent you, sir.
Say something?
Do you wish to be heard on bond?
I'm sorry. Okay, I thought you were saying, I thought he was trying to talk to you, Your Honor.
Your Honor, he has very little criminal history. However, he is at least now a 3-state offender, Texas, Nevada, and Florida. So state has no objection to a bond reduction.
Yes, Your Honor.
Yeah.
He has no failures to appear, and he is currently transient.
All right, sir. Your bond will be, but given those facts, counselor, what is even
He's not,
even if I reduce it to $500?
he doesn't qualify because of the multi. Your Honor, just given the fact that he has 3 misdemeanors, but he has no failures to appear, nonviolent offense, my client's transient, I would ask for an ROR if he registers with the clerk's website so he can get his court dates, as well as call his attorney once a week.
I'll do that. Mr. Brown, I'm going to release you on your own recognizance, but you understand that you still have to come back to court. You understand that, right? I see that you're nodding your head. Are you saying yes?
Yeah, I don't have my glasses. They broke.
Oh.
Yeah.
It's hard to hear.
And
I mean,
see, yeah. I can't see.
I got it. Everyone keeps looking at you. Everyone looks at her. I don't, all right. So make sure you follow your attorney's instructions, because if you don't come to court, you could be arrested for that.
Yeah.
Okay.
All right.
Why? Do I have a mask on? Like, you can see my lips moving, right? Am I invisible?
I think it's because you're not in
They
the
all
room.
look at her. And I got it when we were all wearing masks. I understood it because, like, you can't tell whose lips are moving, but my lips are moving and hers.
And they still look.
I mean, she has a mask on. They wouldn't know. But nobody looks at me. It's hilarious.
It's the robe.
All right. Yeah, because I don't have the robe on. It's at the dry cleaners. This was a great week to dry clean it.
Corlin Vandersloot.
You're here in 22 CF 8424, charged with burglary of an unoccupied dwelling, possession of drug paraphernalia, and criminal mischief, damage greater than $1,000. There is probable cause. I'll appoint the public defender's office to represent you. She has active warrants, counselor.
That's what I
It's been served. It's
Okay.
for a grand theft that should be seen tomorrow.
Okay.
Oh, why didn't we see her today?
It was served after the cutoff time. You wouldn't have had the paperwork.
Oh, that's too bad. All right, well, I'll see you tomorrow. All right, so your bond on count 1 is $5,000, count 2 is 100, count 3 is 500. You can have no contact with any victim, witness, or co-defendant in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition, possess or consume any controlled substance without a valid prescription. You can't return to this scene for any reason. Good luck, ma'am. I'll see you tomorrow.
Enos Danai.
You're here in 22 CF 8430, charged with battery with 1 prior offense.
Your Honor,
PTT case.
I'm going to appoint the public defender's office to represent you. And I just had a discussion about this, counselors, and I cannot remember what the outcome was. For purposes of PC, does it have to have the date of the prior battery conviction contained within the affidavit?
I believe so, Your Honor.
Yes, Your Honor.
Is it in there?
Let me see. I didn't even notice.
That was my question, because I don't think I remembered seeing it, but hold on.
I don't believe I see it, Your Honor.
There were 66. I wrote a note that said, where's the prior?
Yes, Your Honor, state would ask for a reset. I believe, I'm also surprised it only came in as a battery one prior, as the victim is allegedly 9 years old.
Yeah. I thought all of that was weird, but I don't see the one prior anywhere.
Your Honor, can we reset this to tomorrow to gain an additional PC affidavit?
Yes, I will give you 24 hours to get additional probable cause. At this time, however, I'm going to stay the bond. Your bond right now is $2,500. You can have no contact with the victim or any witness in this case. You can't have any contact with any minor child under the age of 18. Do you live at the Heritage Hotel?
yes, ma'am?
Do you live at the Heritage Hotel?
Yes, ma'am.
That's a problem. I don't know what to do about that, guys.
Yes, Your Honor, I would just, he said he could, as long as he gets the one-time return with law enforcement, he can go to a different hotel.
All right, I'll authorize a one-time return with law enforcement. Then after that, you can't go back to the Heritage Hotel. You understand?
Yes, ma'am.
All right, if you've not posted this bond, I'll see you tomorrow.
Excuse me.
Adrian T. Dove.
Mr. Dove, you're here in 19 CF 5248 because a capias was issued for your arrest for failing to appear on a charge of grand theft of a motor vehicle. The bond authorized is $5,000. I'll appoint an attorney to represent you. Good luck, sir.
I mean, question was, because I was incarcerated.
On Felix.
Sir, you're here in 20 CF 4282. An information was filed by the state of Florida charging you with battery on a uniformed security officer. The bond authorized on that is $5,000. I'll appoint an attorney to represent you. You can't have any contact with the victim or any witness, and you can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
All right, good luck. This day, that matters.
Mark Anthony Frazier.
Mr. Frazier, you're here in 22 CF 8415, charged with grand theft of a motor vehicle. I'm going to appoint the public defender's office to represent you. Did you wish to be heard, counselor?
No, Your Honor. I don't think so, not on this one. No.
All right, there is probable cause. Your bond will be $2,500. You can't have any contact with any victim or witness in this case. Do you understand?
Excuse me, ma'am, my bond was already set, but you raised my bond? It was $1,000, ma'am. I was supposed to post that bond today, please.
All right, hold on a minute. I did not look at the bond that was on the PC affidavit.
see
I
it
looked at I read the PC affidavit, there is probable cause, and then I looked at his history. However,
There seems to be several other theft offenses, including being released from DOC approximately a year ago for a theft offense, prior grand theft motor vehicles, prior grand thefts, stealing stolen properties, burglaries. State believes that's reasonable, given the facts within the affidavit and Mr. Frazier's history,
that is why I set it at that number.
in-state and out-of-state.
Your Honor, although he has an extensive history, if you look, there's only one failure to appear, and that was back in 2001. So it does appear that he shows up for court. He's been in the Orlando area for well over a year, so I just ask that you would consider reducing to $1,000.
Please, Your Honor.
Back to 1,000.
All right, I'll stay at 1,000.
Thank you.
Good luck, sir.
Thank you, ma'am.
Alias Green.
Mr. Green, you're here in 19 CF 7408 because a capias was issued for your arrest for failing to appear on a charge of petty theft with 2 prior offenses. There's no bond authorized on that, and I'll appoint the public defender's office to represent you. Good luck. Oh.
You said the bond?
I did. There's none. On that guy, there was none. Right? Yeah, none. FTA for who? Green.
What happened to, Gainey, 22016817?
Oh,
What
I don't
happened
have that one.
to 22016805, Fisher?
Find it.
Thank you.
Okay.
Dennis Hayes.
Good afternoon, sir. You're here in 22 CF 8429, charged with possession of cocaine, destruction of evidence, possession of methamphetamine, possession of cannabis less than 20 grams, possession of drug paraphernalia, and resisting an officer without violence. Hold on one moment. Oh, no, that's right. Okay. There is probable cause. I'll appoint an attorney to represent you. I'll stay the bonds as listed in the affidavit, $2,000 on counts 1. Hold on.
Your state has no objection to cheating them as subsidiaries.
Right, that's what I'm gonna do. So it'll be 2,000 on count 1, 150 on 2, 3, and 100 on 4, 5, and 6. Sir, you can't possess any controlled substance without a valid prescription. You can't have contact with any known drug dealers. You'll be subject to random drug screens. As for the other case, is he actually out on bond?
Yeah.
This one I did not write a note about the dates.
1 second, Your Honor.
Yes, Your Honor, I believe.
Yeah, he
was seen
bonded
on
on
the
7/6.
He was seen on the
Just was
5th.
arrested on that 7-5 and bonded 7-6.
I know, let me see.
That's a problem. It's also drug charges.
Would you, I don't even know if you can afford it. Your Honor, would you be, since they're nonviolent offenses, would you be willing to revoke and double? Since you added, I don't see that they had random drug screens on the out on bond. I'm not sure he was doing that, but if we do the out on bond random drug screens through pretrial services, if he violates, he could be brought back here and held at no bond. That would assist in keeping him clean, Your Honor.
What says the state?
Your Honor, it doesn't appear that Mr. Hayes has a lot of other drug-related history. This seems to either be potentially a new issue for Mr. Hayes, or he just hasn't been arrested for it previously. State's main concern is it's been 10, 15 days. It's been approximately 2 weeks, and they are the exact same offenses. However, it doesn't appear he has a lot of other drug history.
That's why I said if we do the random, he wasn't doing random screens if we add that.
And I was trying to see if he was compliant with law enforcement, and he was not. So Your Honor, state will just leave it within your discretion, whether to revoke and set it none or revoke and double.
In that case, it looks like the bonds were not treated as subsidiaries, so it says on the out on bond form, hold on, it says he posted, I can't read that writing, maybe 2,000, 1,000, 1,000.
That's what I have.
So if I revoke and double that, that's a whole lot of money.
Be $8,000 on top of this
What
new
he's already
case.
done.
It'd be approximately $10,000 total between both cases.
Come up with the money.
Does he have a job?
He's on social security income, Your Honor. That's what I was discussing about the bond. Said one of them was 2,000, Your Honor.
On his out on bond, the meth
But
was 2,000, the cannabis over 20.
No, under 20.
Was 1,000, and
Yeah.
the paraphernalia was 1,000.
Your Honor, he is on social security income. He's
Yeah.
not gonna be able to afford it. But he has no failures to appear. Most of his history, all I see is a driving and a fleeing. I see some out-of-state history too, but majority here, I don't see any failures to appear or anything. My only thing is if we do the random drug screens, if he tests positive, then he can be brought here and held at no bond, but he doesn't have an extensive drug history, so the behavior is out of the norm. That's the only option.
Well, I already ordered the random screens on this case, right?
I'm asking random screens on the out on bond.
Here's what I'm gonna do, Mr. Hayes. Don't make me regret this. I'm gonna take no action on your out on bond cases. I'm looking at your history. I'm looking at your ties to the community. I'm looking at all these offenses. I'm not gonna revoke your bond. Good luck.
Your Honor, Hillman is outside medical.
Oh. All right, so that's 22 CF 7235. Ms. George, he's in medical but outside. So I'm gonna appoint your office.
Who is Hillman, Your Honor?
Yes, ma'am.
Can we reset for 24 hours from him being released from outside, Your Honor? I don't.
We can. That's up to you.
Because he's outside medical and he has an extensive out on bond. He has multiple out on bond cases. So if he's gonna be revoked, it's better if he's here to know
All
what's
right.
going on.
So can we do that? Reset for when he gets back? And you'll notify the clerk? Okay.
Yes.
We have Ingram bonded.
Yeah, my name is Anthony Irizarry Cruz.
Sir, you're hearing 21 CF 11800. A capias was issued for your arrest for failing to appear on a charge of carrying a concealed firearm. There's no bond authorized at this time, and I'll appoint an attorney to represent you. Good luck.
I'll let him know.
Okay, good luck.
Antonio Jackson.
Mr. Jackson, you're hearing 22 CF 8428, charged with petty theft with 2 prior convictions. There is probable cause. I'll appoint an attorney to represent you.
Yes, ma'am.
Your bond is $1,000. You can't return to the scene, and you can't have contact with any victim or witness. Do you understand?
Yes, ma'am.
All right, good luck, sir. Ms. Vickers, do we have your case coming up?
I believe so, Your Honor.
Okay. I'm just checking. You're being very patient sitting there, but.
James Jackson.
Mr. Jackson, you're here in 22 CF 8420, charged with grand theft of a motor vehicle. There is probable cause. I'll appoint an attorney to represent you. Your bond is $5,000. You can have no contact with a victim or any witness in this case. I'm sorry. Your bond is $2,500. Sorry about that. I read my handwriting wrong. No contact with any victim or witness in the case. Good luck, sir.
Here you go.
Oh, all right. I have a face sheet for him.
Who?
Hold on a minute.
Who's it?
Bryce Ingram.
I don't know where he
It's
is.
like 4 cases ago.
4 cases ago?
I have a case
I
number
don't
if
have
it'll be
the
easier for you.
Oh, I see.
You're here in 22 CF 8432, charged with improper exhibition of a firearm or dangerous weapon and aggravated assault with a deadly weapon. Do you wish to be represented by an attorney?
Yes, ma'am.
Do you have the money to hire an attorney?
Yes, ma'am. I talked to my mom to schedule that.
All right, so you're going to hire your own attorney? Does he have an attorney?
Not at the moment.
Okay. All right. There is probable cause, sir. I reviewed the affidavit before court. At this time, your bond will be $2,500 on count 1, $2,500 on count 2, with special conditions. You can have no contact with the victim, any witness, or the co-defendant in this case. Do you understand what no contact means?
Yes, Your Honor.
You can't return to the Wawa at 901 North Orlando Avenue in Winter Park, Florida. You can't possess a weapon of any kind, firearm, or ammunition. I believe this firearm was confiscated by law enforcement.
I believe so, Your Honor.
Okay, I just want to make sure I remembered that correctly. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir, and let your attorney know right away.
Yes, Your Honor. Thank you.
Yes, sir.
LeVar Jones.
22 CF 628AO, you're here because a capias was issued for your arrest for failing to appear on charges of possession of firearm by a convicted felon. The bond authorized on that capias is $10,000 on each count. I'll appoint the public defender's office to represent you. Good luck, sir.
I already have a public defender on this case.
Okay, then you'll keep them.
We have night as outside medical.
I'm,
22 CF 8433, I'll appoint your office, Ms. George.
I will waive the appearance, Your Honor.
All right, this is one of the co-defendants. There's a case today with a bunch of co-defendants. There is probable cause.
The only reason I waived, Your Honor, is her out on bond is a driving while license suspended. Because they're unrelated, I would ask that you take no action on the out on bond.
State has no objection, Your Honor.
All right. Bond is $5,000 on count 1, 100 on count 2, 100 on count 3. No contact with victim, witness, co-defendant, no return. No weapons, firearms, or ammunition, and no drugs without a valid prescription, random screens. What? Oh, no action, yes, thank you.
Anthony Corrali, ma'am.
You're here in 22 CF 8406, charged with aggravated assault with a deadly weapon. There is probable cause. Sir, do you wish to be represented by an attorney?
I will be, yes, ma'am.
He qualifies? I'm surprised. It says he's retired. That qualifies? Sir, do you have the money to hire your own attorney?
Yes, ma'am.
All right, I'm not gonna appoint the public defender's office, but you're gonna wanna contact your attorney right away about your case, sir. Give me one moment.
Ma'am,
Yes, sir.
my wife was dealing with Nejam and Associates, and they said that the PD would handle the bond issue for me.
No, they don't do that, unless we appoint them.
I don't know what to do then.
Well, what we're gonna do today is I'm telling you what the charge is. It's aggravated assault with a deadly weapon. I did review the probable cause affidavit. There is probable cause here. Sorry, I'm in the middle of an allergy thing. This is not COVID.
I was told it would be bond.
Negative test.
There will be.
I will set bond. All right, sir, your bond in this case will be $5,000. With special conditions, you can't have contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm or ammunition. And, I mean, it took place on the roadway between places, so I'm not gonna say no return. All right, good luck, sir. Get in touch with an attorney.
Thank you, ma'am.
Jamarcus Keon Lane.
Sir, you're here in 22 CF 8440. A warrant was issued for your arrest, charging you with unlawful use of a two-way communication device, possession of cannabis with intent to sell or deliver, possession of cocaine with intent to sell or deliver, possession of cocaine. Another judge has already found probable cause. I'll stay your bond at $2,500 on count 1, $100 on count 2, $3,500 on count 3, $5,000 on count 4, and $1,000 on count 5. With special conditions, you can have no contact with any known drug dealers. You can't possess a weapon of any kind, firearm or ammunition. You can't possess or consume any controlled substance without a valid prescription. And I'll take no action on the out on bond. They're not truly out on bond. Yes, sir.
I actually for this, I was arrested back, if you look at the,
Stop.
I know.
She's taking no action.
I'm not revoking those bonds because of, I looked at the dates.
Thank
I know what you're about to tell me. I did. I went back and looked at those dates. It's the same day. So I won't revoke those. You can ask anything you want.
on count 4, can you help me, because I really don't have to find it,
Wait, I can't understand you. Get to
it's too excessive, count 4, so I was asking if, like, you can lower it a little bit.
possession of cocaine with intent to sell or deliver.
$5,000.
I often set that at 10,000. So I didn't raise it. I left it at 5,000, but I am not inclined to reduce it beyond that.
Thank you.
Yes, sir. I'll appoint the public defender's office to represent you.
Your Honor, doesn't he have another case as well?
Oh, hold on,
There's another cocaine and Willis.
hold on. I didn't read that one. Give me a minute. I did not see that there were 2 cases. Because the way it appears on my sheet, it's not clear. Give me a second.
You have warrant and you have the arrest, where he arrested you. You picked up a cocaine and the driving while license suspended.
All right. In this case, you're charged with possession of cocaine and driving while a license suspended, canceled, or revoked with knowledge. I'm reviewing the probable cause affidavit. There is probable cause here. All right, sir, in this case, I'll stay your bonds as is in the probable cause affidavit, $1,000 on count 1, $100 on count 2. You can't drive without a valid Florida license. You can't possess or consume any controlled substance without a valid prescription. Good luck, sir. Thanks, y'all.
That's where the add-on bonds came in from, Your Honor.
What up?
That's where the add-on bonds came in from, because it's of his new law violation.
Oh, I see. And they were out on bond for that one.
Claude Ledger.
Mr. Ledger, you're here in 22 CF 3619. The state of Florida filed an information charging you with uttering forged bills, bringing into the state forged bank bills, and grand theft of $20,000 or more. I'm sorry? I see. I'll stay your bond at $1,000 on each count. You can have no contact with any victim, witness, or co-defendant. Sir, do you wish to be represented by an attorney?
Yes, I have a lawyer.
You have a lawyer?
Yes, ma'am.
All right, contact your lawyer and let them know what happened today.
Ma'am.
Good luck, sir.
Gary Mannion.
You're here in 22 CF 8410, charged with possession of cocaine, drug paraphernalia, and resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 each on counts 2 and 3. You can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
All right, good luck.
So is there, what does that mean, time served?
No, no, no. I'm just telling you what your bond is. These cases are not resolved. This case is not resolved, and you'll have to come back to court.
Okay, and how long is the time served if you pick time served for possession?
I'm sorry, what's your question?
Like, if you pick time served for possession of cocaine, how long do you pick? How long is it?
All right, so I'm not really sure I understand. What?
How long would time served be for possession of cocaine?
I think she's asking,
That's not, okay, so the way it works is possession of cocaine is punishable by up to 5 years in prison. If you're asking me what will a judge accept as a plea agreement, that's between you, your lawyer, the state, and that judge. But I can't tell you that today because I'm not the judge that will be accepting that plea.
Okay. Thank you.
Yes, ma'am. Good luck.
Tyrese Marshall.
Mr. Marshall, you're here in 22 CF 8411, charged with grand theft of a motor vehicle. There is probable cause. I'll appoint an attorney to represent you. Your bond is $5,000. You can have no contact with any victim or witness in the case. Do you understand? Good luck, sir.
Can I ask a question?
Yes, sir.
I can't get PTR.
No. Does or does not. What's your name?
Jason Metzler.
22 CF 8407, you're here charged with burglary of a structure, criminal mischief, damage greater than $1,000, petty theft, and resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you. Oh, I'm sorry, you don't qualify for the PD. Sir, if you want an attorney to represent you, you're going to have to hire one yourself. Do you understand?
Ma'am.
All right. Your bond is $5,000 on count 1, $1,000 on count 2, $500 on count 3, $500 on count 4. You can't return to the scene for any reason or have contact with any victim or witness in the case. Do you understand?
Ma'am, how much is that, like the 10%?
Well, that's between you and a bondsman. I don't know if you have to negotiate that with a bondsman. Unfortunately, however, sir, you're out on bond in 3 cases. And so at this time, I'm revoking those bonds. So you're gonna have to talk to your attorney about filing a motion in front of your trial judge. Good luck, sir.
Oh, I can't make bond?
Right, you can post it in the new case, but I've revoked it in the old cases.
I'll go to court for that next Friday.
Okay, so that, you'll wanna talk to the judge about that.
All right, so I gotta stay till then.
Or you can talk to your attorney. If your attorney files a motion before then, you could get out before that.
Stephen Mitchell, Medical, Your Honor.
22 CF 8175. Ms. George, I'm going to appoint your office.
I will waive the appearance and the reading, Your Honor.
All right. I'm going to set the bond at $15,000, must comply with all reporting requirements.
Morning, ma'am.
Morning.
Frank Maurice Mills.
All right, hold on a minute. I think we have someone on the line. How do I get to the? Video conference? This is video conference, is that it?
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
That's not a good sign. Give me 1 minute, Mr. Mills. You have an attorney, right?
Yes, ma'am.
All right, hold on a second.
I believe Corey Cohen's office.
Right. That's what I have as well. But he's not here. Let's skip Mr. Mills for the moment. Can we do the next gentleman behind him and then, because I want to see if we can get his attorney on the line. Hi, please tell me your name.
Antonio Murphy, ma'am.
All right, Mr. Murphy, you're here charged with robbery and retail petty theft. There is probable cause. I'll appoint an attorney to represent you. Do you wish to be heard on bond, Ms. George?
Your Honor, I point to the fact that my client's on Social Security, disability. This is Murphy, yeah. And just looking at the robbery. Your Honor, I just ask that you take into consideration the facts in this particular case when setting the bond. I see the petty theft. I'm not sure about the robbery, Your Honor, if the state's gonna be able to move forward on the robbery. So I just ask that you consider the facts when setting the bond on both charges.
What says the state?
Your Honor, I would just bring your attention that he does have 5 prior failure to appear, last being in 2019, approximately 2 to 3 years ago. In regards to the robbery, I do believe arguably there also could be several batteries as well on multiple different people. There's several, I believe, elbow strikes.
Don't talk. Don't talk.
So I believe that is partially where the robbery comes in, Your Honor, as it is there was batteries when trying to get away from the Macy's staff and loss prevention officers. Usually robbery comes in higher than $1,000, the state would just ask that you stay what's currently there, as the officer thought that was reasonable, even though Mr. Murphy does have a pretty lengthy and extensive criminal history, both in and out of state. State would just ask that you stay the bonds with normal conditions.
No objection, Your Honor.
Yeah, I was gonna raise it. But based on your arguments, I'll not. Mr. Murphy, your bond will be $1,000 on count 1, $500 on count 2, with special conditions. You can't return to the mall for any reason. Which mall was this?
I believe it was
Florida Mall.
Florida, yeah.
Sir, you can't return to the Florida Mall for any reason, you understand? You can't have contact with any of the victims or witnesses in the case, and you can't possess a weapon, firearm, or ammunition.
Understood.
Good luck, sir. I still don't have his attorney yet. Can we bring him back in? I'm just gonna, I wanna try to get his attorney if we can.
Yeah.
Marnell Charles Palmetier Jr.
All right, sir, you have several cases. Give me 1 moment.
He just here on the 22
Only
CF
one.
8401 case, Your Honor.
Okay, good. That's the only one I wrote about. I was starting to get really worried. I had to read 4 others. 22 CF 8401, you're here because a warrant was issued for your arrest for violating your sex offender reporting requirements. Another judge has already found probable cause. What? Does he,
So what about what I was booked
oh, it's
for?
not a warrant? Hold on, I wrote that wrong.
It's an affidavit, Your Honor.
No, it's probable cause. I wrote that, sorry.
No, it's just a regular.
I can't read my own writing. I was trying to write really quickly. All right, sir. Let me start again. This is a probable cause affidavit. I reviewed the affidavit before court. There is probable cause here for this charge. Do you wish to be represented by an attorney?
Yeah, public defender?
Do you have the money to hire an attorney?
No.
Did he complete it? Okay. All right, I will appoint the public defender's office to represent you. Counsel, do you wish to be heard on bond?
Your Honor, I just ask that you consider the fact that he has no failures to appear when setting the bond in this case. I hate these failures to report.
Does the state wish to be heard?
Your state's main concern is he also has that 2021 failure to report. And I believe he was just released from DOC on that underlying offense that made him a sexual offender in 2020. So it appears it's been an issue 2 years in a row since making him that status. So state would just have you take that into account when setting his bond.
Well, maybe prices of shit should stop going up.
Sir, I can't hear you.
Stop talking.
Yes, ma'am.
All right. At this time, your bond is $20,000 with special conditions. You must comply with all sex offender reporting requirements. Do you understand that? You have to answer out loud.
Yes, ma'am.
All right, good luck, sir.
I do have,
Yeah, if you have a question, you can ask it.
for what I'm booked for,
Yes.
what about that? Nobody's told me anything.
You mean other charges?
Yeah, they.
I don't have any other charges. I just have this one arrest affidavit. Okay, good luck.
Shalonda Patrick.
22 CF 8414, you're here charged with criminal mischief, damage greater than $1,000. There is probable cause. I'll appoint an attorney to represent you. Did you wish to be heard on bond, Ms. George?
Just consider, I would ask that you consider the very limited criminal history, Your Honor, when setting the bond in this case. She has mental health issues, I just can't see. I can't see any of them.
Anything from the state?
Just echoing the PD, Your Honor.
All right, at this time, ma'am, your bond is $500 with special conditions. You can have no contact with the victim. Were you living there?
I was.
Do you still have belongings there?
I do.
All right, I'm going to order that you maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings.
Okay.
All right, good luck, ma'am.
Marquia Tache Prince.
You're here in 22 CF 8226. A warrant was issued for your arrest, charging you with armed burglary of a conveyance with a firearm and grand theft of a firearm. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard?
Yes, Your Honor, as to count one, it is a first-degree felony that's punishable by life. State's asking that you hold Ms. Prince at no bond pending an Arthur hearing downtown at a later time.
All right, what says the defense?
My only argument, Your Honor, she has very limited criminal history. Other than the trespass and some, it's like, I don't know what the out-of-county is. She has no history of violence. No failures to appear, no indication she wouldn't show up for court. So I would just ask that you consider using your discretion to set a bond in this case. I just couldn't remember if the weapon was already in the, yeah, it was stolen.
The weapon was already in the vehicle.
Mm-hmm. Yeah. So, it's not as if she showed up with a firearm, Your Honor. So I just ask that you consider the facts, her history, and consider using your discretion to set a bond. She's currently employed. I don't see her as a violent person in the community based on her history, Your Honor.
However, I believe the co-defendants also had firearms, Your Honor. There were several.
In there?
I believe there were like, there's a Blacksmith & Wesson 40 cal, there's a extended 40 cal mag in the bag, there was a Ruger 9mm, there was, I believe something else I read. There's like 4 to 5 firearms with multiple different co-defendants.
But she, it wasn't her, right? I understand the other ones, but she hasn't moved it. Even if you said a hot box.
All right, I appreciate the arguments from both sides on this. However, I'm not going to make any findings, and I'm not going to use my discretion at this time.
Yes.
So at this time, ma'am, you'll have no bond on count 1. Your bond on count 2 will be $15,000. However, even while in custody, you can have no contact with any victim, witness, or co-defendant in this case. Do you understand?
Yes, I understand.
All right, you want to get in touch with your attorney right away. They'll file a motion in front of your trial judge for bond.
That's my attorney.
Mm-hmm.
Ravindra Ramawad?
Good afternoon. You're hearing 21 CF 3439. An information was filed charging you with a scheme to defraud and 5 counts of petty theft.
Yes.
At this time, I'll stay the bonds as listed, $1,500 on count 1, $500 on counts 2, 3, 4, 5, and 6 each. You can have no contact with any victim, witness, or co-defendant. Is there any other, no return and no weapons? And no drugs. He might already have an attorney. Do you have an attorney in this case?
Yes.
All right, so I'm not appointing the public defender's office. All right, good luck, sir.
Timothy Redding, ma'am.
Good afternoon, sir. You're hearing 22 CF 7275 because a warrant was issued for your arrest, charging you with trafficking in MDMA, sale or delivery of a controlled substance, 2 counts of that, possession of a controlled substance with intent to sell, possession of cannabis with intent to sell, possession of drug paraphernalia, and I think that's it. Counselor.
Good afternoon, Your Honor. Melissa Vickers on behalf of Mr. Redding. First of all, I'm just confused because what the charges are in the warrant and what is on the clerk's site and what is on the jail are 3 different things. And so that really needs to be clarified as to what charges we're addressing. I do have various probable cause arguments depending on which charges, and I'll submit to you what charges I think should be considered.
Well, the arrest warrant has trafficking in MDMA, sale or delivery of a controlled substance, 2 counts of that, possession of a controlled substance, 1 count, possession of a controlled substance with intent to sell, 1 count, possession of cannabis with intent to sell, 1 count, and possession of drug paraphernalia. So that,
right.
I think no matter what anybody else has, that has to be the charges we look at, right?
Okay, right. So that's, I believe, only 6 counts. Is that correct?
1, 2, 3, 4, 5, 6, 7. 7.
Which warrant, because I'm looking at the application and affidavit for arrest warrant, and on page 2, it only has 6, I'm seeing 2 counts of that. Okay, so
Yeah,
I'm
'cause
sorry.
it says
So
in print, it doesn't lay it out
I understand.
clearly
So-
like it should.
On count 1 of trafficking MDMA, the jail has it listed as over 200 grams. There's no probable cause for that. At most, they found, I believe, 14.03 grams is listed in the arrest warrant. So I would ask the court to find no probable cause for trafficking in MDMA over 200 grams. There's a significant difference in 200 grams, over 200 grams versus 14.03 grams. It's a completely different classification. Do you want me to just go one by one, or do you want me to
Well,
do everything at once?
what's in the search warrant? I mean, what's in the arrest warrant? Because I don't think it matters what the jail has. Well, I think it matters what the judge signed, because the judge has already found probable cause in a warrant. So if the judge found probable cause for over 200 grams, it's already done.
It doesn't say, it just says trafficking in MDMA in the warrant, but the jail has it listed as over 200 grams with a $100,000 bond. And my argument would be is if the bond was set with the understanding that it was over 200 grams, I understand that, but it's clearly 14.03 in the arrest warrant, which is, again, a completely different classification. It takes it down.
Well, what I see in the warrant is that defendant Timothy Paul Redding was in possession of over 14 grams of MDMA. That's on page 4 of 6.
I understand, but the concern again is that with the setting of the bond, it's listed as over 200 grams. And so if the court finds that there's probable cause for trafficking, I would ask that the bond on that, which is $100,000, be reduced. And at the end of my probable cause arguments, I can give you arguments for bond.
Your Honor, I believe I may help clarify Ms. Vickers' argument. Upon reading the affidavit, I do see it's 1403, which would be in the first classification, so 14 to 28. So, and since there was not an allegation of a firearm, the bond schedule comes in at 50. So state has no objection to count 1 being set at 50.
I would ask for lower than that, and I can explain my reasons why.
Okay, well, that's fine. Let's just go with that. But I think that as a base, we should start with what's in the warrant, because what the jail has or what the clerk has is not controlling. It's what the judge already found probable cause for. So let's just go with that. So it's
Understood.
14 to 28 grams.
Okay, I would ask though at some point that some kind of correction be made, because what I foresee happening is that if we get this all straightened out with us, the jail's gonna say, oh, well, this count was never addressed because there's listing something with a weapon, which there's nothing about a weapon in any of these. And so I just wanna make sure that whatever the court is doing does get straightened out with the jail, because they will consider those extra charges and just not deal with it.
Yes.
Okay.
I agree with that.
My next probable cause argument is that there are 2 different counts for sale and delivery of controlled substance of DMT. Those are the exact same counts. There's no probable cause for 2 different counts. Although on the arrest warrant I'm looking at, I'm seeing 3. Well, it's 2 sale and deliveries and then a possession of DMT. I would argue that it should be 1 count. If you would like to take the higher count of sale and delivery of DMT for 1 count, I understand that's acceptable, but there shouldn't be, possession is a lesser included of sale and delivery. There shouldn't be 3 different counts of sale, delivery, or possession with DMT. It should just be 1 count.
What says the state?
Your Honor, given that it's not filed currently, he can't be arrested on the higher case and the lesser included, so state would argue that at this time, bond can be set on both and PC can be found for both, which has already been found.
Well,
I thought that the 2 counts were for 2 different individuals.
I'm trying to clarify that right now, Your Honor.
It says on page 5 of 6 that he performed the ceremony for the decedent, count 1, and the friend, count 2. So I thought that the reason there were 2 counts is, the allegation is he did 2 different sales or deliveries.
Yes, that would be for the sale and delivery. I was talking about for the delivery and then the possession, since I believe the argument was there shouldn't be also possession since there was a delivery.
I thought she was arguing there shouldn't be 2. I'm sorry, Ms. Vickers. Maybe you can clarify
No,
for us.
I'm arguing there shouldn't be 3 counts. Number 1, there's no technical sale or delivery, as no consideration or anything was given to Mr. Redding for allegedly supplying DMT to these people. These people paid for a ceremony to attend, which included hiking, which included spiritual treatment, things like that. There's nothing in the friend's statement that says that they paid for drugs, requested drugs, did any kind of drug transaction. So I'd argue, number one, that there's no consideration given, so therefore you don't have a sale or delivery for those two. If the court is considering finding that there's probable cause on those, I would again argue that it shouldn't be two sale and deliveries and then one extra possession. It should all be one charge. And the alternative, I would ask that if the court is remaining with probable cause, that two of those counts at least be ROR'd.
All right, next argument.
As far as the charges in the warrant affidavit, I don't have any more probable cause arguments. I do have bond argument.
All right, go ahead.
So this happened back on August 1st of 2021, and my client has been under investigation ever since, and he knows he's been under investigation ever since, and he's not left the area. I can either ask him questions, or I can proffer to the court that his address is 3023 Hidalgo, it's Hidalgo Drive, Orlando, Florida, 32812. He lives there with his partner and brand new baby that was born, less than a month ago? The 1st of July. So brand new baby. He hasn't gone anywhere since August, almost a year ago. He's not planning on going anywhere. He knows about these charges. He has no prior failure to appear in court before. He has ties to the community and that he has family, he has friends. He also volunteers with various organizations such as the Landmark Forum, the Valencia College Peace and Justice Institute, and the Sioux Nation. He is self-employed, doing counseling and consulting, and his income, especially since COVID has started, has been taken a steep dive. And in speaking with his partner, and when I say partner, I mean like relationship, girlfriend, fiance, mother of his child, she explained that they could afford anywhere from like $5,000 to $7,000 for a bond. So I'm asking the court to consider that, if the purpose of bond is to make sure they're going to show back up to court and they're not a danger to the community, I would argue that he's absolutely going to show back up to court because he's not left the area. He's been under investigation. He's had an attorney since shortly after that investigation, myself, and we have been in contact this entire time. He has not fled the state, has not fled the area. I would also argue that he is not a danger to the community. I understand what's in the affidavit and I understand what's alleged, but these people came to his home. These people agreed to participate in this activity. And I would argue that he is certainly not a danger to the community. He's never been accused of anything like this before in his time doing this in here. And that therefore I'm asking for like a total bond to be set of like $7,000.
All right, do you want to take testimony?
I can, if you need me to verify all of those things through testimony.
Well, that's up to you. It's your case. None of that is evidence on the
Okay,
record.
yes, I will take
but-
testimony. Mr. Redding, could you please state your address?
Let's swear him in.
Raise your right hand, please. Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Mr. Redding, what is your address?
3023 Hidalgo Drive, Orlando, Florida.
And were you aware shortly around August 1st of 2021 of the investigation in this case?
I was.
And did you employ an attorney for purpose of that investigation?
Yes, ma'am.
And since that time, have you been in contact with your attorney?
Yes, ma'am.
And have you moved out of the area since that time?
No, ma'am.
Are you currently working?
Yes, ma'am.
And currently, what is your job?
I help different people with problems, counseling, basically.
And do you volunteer with any local organizations?
I work with veterans with the Peace and Justice Institute and with Valencia College and Landmark Forum.
And what kind of volunteering work do you do through these organizations?
I'm mainly working with veterans with PTSD and related problems like that.
Who do you live with?
My partner, Nicole Woodall.
And how long have you guys been in a relationship together?
About 4 years.
And did you recently have a child?
We did. June 1st is.
June 1st. Okay.
July, I'm sorry.
July 1st. And do you currently live with Miss Woodall and the child?
I do, thank you.
Okay. And this is your biological child?
Yes.
Okay. Is this your only child?
Only child.
Okay. Have you ever failed to appear in court before?
No, ma'am.
If the judge were to order you to come back to court, do you have the ability to show back up to court?
Of course, ma'am.
And do you have the willingness to show back up to court?
Yes, ma'am.
Okay. Have you ever been arrested or accused of any type of violent crime?
No, ma'am.
And then how much do you think between yourself and Nicole that you all could afford to pay for a bond?
She does the finances, but she said 5,000, I believe.
Okay. Nothing further.
All right, any cross?
No questions, Your Honor.
All right, thank you. Thank you, Mr. Redding.
Your Honor, just brief argument.
All right, well, hold on. Let me just make sure. Anything else, Ms. Vickers?
Your Honor.
All right, go ahead, state.
Regarding, I believe Ms. Vickers' earlier argument regarding the 2 counts of the delivery and then the 1 count of possession. A, PC has already been found for that. But B, even though the possession is a lesser included of the delivery, there's still gonna be a bond set on it. I believe it already is semi-treated as a subsidiary. And delivery is just giving a substance to another, which is alleged within this affidavit to the two other people. Regarding Mr. Redding being a danger to the community, he doesn't have any other violent history. It appears breaking and entering, larceny, credit card fraud, and possession of other drugs. However, state would argue that he is partially a danger to the community in the illicit nature of the substances that he uses to perform these rituals and spiritual cleansing rituals. As one of the members is deceased. Also, in regards to his history, it does appear that he has some out-of-state history, one including a VOP. So showing partially an inability to comply with some court orders. So in regards to bond, count 1, I believe the bond schedule comes in at $50,000. State has no objection to that being set at 50. And then treating some of the others as subsidiaries. However, given the allegations within the affidavit, the amount of drugs that were allegedly part of these rituals and found, state believes that would be reasonable at this time.
All right, thank you both. Anything else, Ms. Vickers?
No, Your Honor, just that I would be requesting an ROR on count 3 and 4, and then, of course, a lower bond on all of the bonds, except for count 7, which is $250.
Your Honor, I also believe there is a VOP from out of state previously. So there was one prior VOP, or failure to appear.
What year is that from, I'm sorry?
I think pretrial may have it. I just have it as a failure to appear.
I just have an
from out of
entry as a VOP. I don't have a date.
Oh, I have a failure to appear and a VOP.
Right, I have no.
2016 out of North Carolina.
Okay.
The failure to appear is 16.
Or the VOP.
No, the failure to appear is out of North Carolina in 2016.
You have the VOP?
VOP? 2004.
All right, thank you. That seems fairly remote in time. All right, here's what I'm going to do, Mr. Redding. And to clarify, I understand both of your arguments about the bond schedule. I don't follow a bond schedule strictly. We use it as a guideline, but I don't ever follow it. What we do is use that as a guideline and then look at the facts and then look at the criminal history, and that's how we determine bond. On count 1, I will reduce that bond. Hold on, let me open something else. Give me 1 second. I will reduce the bond on count 1. Let me get back to that one. I'm still considering that. Count 2 will be 5,000. Count 3 will be 150. Count 4. Hold on, that's not right. Sorry, I'm trying to find the warrant because that's what I have to go by. 1, 2, 3, 4. Count 4 will be 150. Count 5 will be 5,000. Count 6 will be 150. Count 7 will be 100.
I'm sorry, what was 1 and 2? I apologize.
I didn't do 1 yet.
Okay.
Did I say 5,000 for count 2?
2 was
I did,
fine.
right? Okay. So count 2 was 5,000. I'm going to set count 1 at $40,000. That's a significant reduction, sir. You should thank your attorney based on her arguments, and I'm treating half of these as subsidiaries. But as conditions of all of these bonds, you can have no contact with any victim or witness in this case. There's no charged co-defendant, right?
No, Your Honor.
You can't possess or consume any controlled substance without a valid prescription. You'll be subject to random drug screens. You can't, I don't want to say that. Are there any other conditions the state would request?
Your Honor, state would just ask for no weapons or firearms as there is at least one F1.
All right, you can't possess a weapon of any kind, firearm, or ammunition, and just continue to stay in touch with your attorney.
I don't know what we have to do to get the jail to fix their.
I don't know either.
Court order, whatever they put on the court order is what the jail will go by.
Okay,
So check that later today and
I'll
see
have
if that
faith.
worked.
Okay, thank you so much.
We'll try.
Everybody have a lovely day.
You as well. Thank you, Counselor.
Thank you.
Amby Robeson.
You're here in 22 CF 8423, charged with burglary of an unoccupied dwelling, criminal mischief, and possession of drug paraphernalia. This is one of the co-defendant cases, y'all. Ma'am, there is probable cause here. Your bond will be $5,000 on count 1, $150 on count 2, $100 on count 3. You can have no contact with any victim, witness, or co-defendant in this case. You cannot return to the scene for any reason. You cannot possess or consume a controlled substance without a valid prescription. You'll be subject to random drug screens, and I'll appoint the public defender's office to represent you. Good luck.
Sahadio Toteram.
Sir, you're here in 2017 CF 14438. A capias was issued for your arrest for failing to appear for court. Hold on 1 second. The charge was scheme to defraud and grand theft. There's no bond authorized on that capias. Sir, do you have an attorney?
Yes, ma'am.
All right. You want to contact your attorney right away.
I did that already.
Okay, great. Good luck.
Good morning, Your Honor.
Good morning. What's your name?
I'm Sean Seagram.
You're here in 22 CF 8221. A warrant was issued for your arrest, charging you with petty theft, battery, and aggravated assault. I'm gonna give you just a minute. It's okay. George?
Sorry, Your Honor.
That's okay.
Thank you, Your Honor.
So a warrant was issued for your arrest, which means another judge has already found probable cause. I'll appoint the public defender's office to represent you.
Yes, ma'am.
I'll stay your bond at 500 on count 1, 1,000 on count 2, 5,000 on count 3. You're not allowed to possess a weapon, firearm, or ammunition, and you can have no contact with the victim or any witness in this case. Do you understand?
Yes, ma'am.
Seagram? Up. It was a battery? Wait, hold on.
You did 5, 1,000, 5,000?
Did I?
You said 500, 1,000, 5,000.
5,000. Oh, I just said it. It had no bond? Oh, sorry, I wrote it down.
Okay, I'm sorry, it was 1,000.
I was writing so fast today, like it's hard for me to read my notes, but I wrote my own bonds there. Yeah.
5,000.
Okay. All right. Good luck, sir.
You said conditions? I'm sorry.
Yes, I did. No contact with the victim or any witness, no weapons, firearms, or ammunition. All right, 22 CF 8409. Ms. George, he's medical. I'm gonna appoint your office.
I will waive the appearance, Your Honor.
He's medical, he's competency issues.
Yes.
Okay, all right.
He has I believe it's a private, is that private or RCC? I believe it's private.
Was it?
On the out on bond, Your Honor, already. We originally had him, but he has a private now for the out on.
All right, well, he's incompetent to proceed on that. So what I'm gonna do is take no action on that, find probable cause on this, set the bond at $500. Because you're waiving for today, I am appointing you, and then if his other attorney wants to take the case, they can.
Yes, thank you.
All right, so he's not allowed to possess or consume any controlled substance. Ms. Spees, you're here in 20 CF 6292 because a capias was issued for your arrest for failing to appear for court on charges of dealing in stolen property, fraudulent use of a credit card, receiving money from a pawnbroker by false verification, and petty theft. At this time, there's no bond authorized on that capias. Ma'am, do you have an attorney representing you in this case?
Yes, ma'am.
All right, then I'm not going to appoint the public defender's office, but you'll want to contact your attorney right away.
Yes, ma'am.
Good luck. Mr. Stokes, you're here in 22 CF 8416, charged with driving while license suspended or revoked, third or subsequent violation. Sir, there is probable cause in this case. I'll appoint an attorney to represent you. Your bond is $2,500. You can't drive without a valid Florida license. Do you understand that? All right, did anyone check the dates on his out on bond case? I did not check that date.
Your Honor, the arrest on that was on 6/25/22. And since he picked up this new law, obviously was out on bond. He bonded on it.
Was out on bond.
And Your Honor, my only argument is that these are unrelated offenses. Additionally, if you read the out on bond, he actually cooperated with police. He gave them all the information they needed as to where the alleged firearms were located in the vehicle. So I just ask that, given that they're unrelated and he was cooperative with the police in that arrest affidavit, that you not take any action.
Thank your attorney, sir. Because of her argument, I'm going to take no action on your out on bond case. Good luck. All right, Mr. Sweat, you're here in, hold on a minute. Let me get this case number right. Okay, 22 MO 825 is alcoholic beverage sale or consumption in a place where prohibited. 22 CF 8419. You're here charged with possession of MDMA. I'm going to appoint an attorney to represent you. Ms. George, did you wish to be heard? There is probable cause.
Yes, Your Honor.
Do you wish to be heard on bond?
Yes, Your Honor. I would just argue that given these are nonviolent offenses, I don't see much of a history here. Most of his history is nonviolent. That you consider an ROR in this case. He has no failures to appear. If he registers with the clerk's website when e-notify and calls his attorney once a week, I would ask for an ROR in this case.
What says the state?
Your Honor, it doesn't appear that Mr. Sweat is a danger to the community. State has no objection.
All right, Mr. Sweat, thank your attorney. Based on her argument, I'm going to release you on your own recognizance, but make sure that you do what she says so you come back to court, okay?
Okay.
No problem, man.
Okay.
No problem.
Good luck.
Andrew Tony.
Mr. Tony, you're here in 22 CF 2298 because a capias was issued for your arrest for failing to appear on a charge of petty theft with 2 prior convictions. There's no bond authorized on that, and I'll appoint an attorney to represent you. Good luck, sir.
Call the attorney to set the motion. I think I said about.
Your Honor, freaks is behavior.
All right, Ms. George, I'm gonna appoint your office in this case. It's 22 CF 8422. It's one of the co-defendant.
I will waive the appearance, Your Honor.
All right. There's probable cause. Bond is $5,000, $150, and $100. No contact with victim, witness, or co-defendant. No return. No drugs, and random screens.
My name is Vincent Michael Yednak Jr.
All right, sir, you're here in 22 CF 8095. Give me one moment. A warrant was issued for your arrest.
I will waive the reading, Your Honor.
All right, I'll appoint the public defender's office. Does he also have a VOP or no? Not here today?
Hey, he does.
It's on view.
It's on.
On view.
Oh, it's on view, okay. All right. I'll set your bond on the warrant at $15,000. You must comply with all your sex offender reporting requirements, and you'll have no bond on the VOP. So you want to stay in touch with your attorney, okay?
I don't have an attorney, ma'am.
I appointed one to represent you. And she's doing a great job today, so you definitely want to make sure you stay in touch with her. Come on up. Mr.
Frank Maurice Mills.
All right, Mr. Mills, we attempted to contact your attorney's office several times.
Your Honor, Rachel Shaw, I'm here for Frank Mills. I've been on the log.
Great. I'm sorry, it didn't tell me that you were here, and so I thought, well, I just have to do without him.
No, that's okay, I'm here.
Sorry about that. Go ahead, Ms.
It's
Shaw.
okay. Your Honor, I represent Frank Mills on his out-of-bond case. I'm not retained on this case yet. I understand a judge did find probable cause at the signing of the arrest warrant. Mr. Mills has provided me a receipt that he wasn't in the city when this incident occurred. I have a receipt from a hotel in Tampa between the dates of July 12th to July 18th. The incident allegedly occurred on July 13th. He was arrested on July 19th. So I would like to argue that there's no probable cause. But if the court does find probable cause based on the initial judge's affidavit signing of the warrant, then we're just asking for a reasonable bond and for the court to take no action on his out-of-bond case.
All right, go ahead. Are you going to present testimony?
Yes, I'd like to take testimony from Mr. Mills.
Go ahead. Raise your right hand, sir.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Mills, are you currently employed?
Yes, ma'am.
Who are you supporting?
All my sons moving in storage.
Are you, how many children?
I have 14 kids, but 6 live with me.
Okay, and you're supporting all of them?
Yes, ma'am.
And if you're released, will you attend court for all your required court dates?
Yes, ma'am, I will.
And you're planning on retaining our firm to help you with this, correct?
Yes, ma'am.
Okay, and were you at the Motel 6 between July 12th and July 18th as evidence in the receipt that your girlfriend sent me?
Yes, ma'am. We checked in July 12th at 1 o'clock, and we left July 18th at 11 in the morning at checkout.
Okay, I have no further questions, Your Honor.
State, any cross?
No, Your Honor.
All right. Any argument, Ms. Shaw?
Your Honor, I'm just asking for either the court to ROR him on this or set a reasonable bond and to take no action on his out-of-bond case, which is 22 CT 717.
All right, give me one moment. All right, since probable cause in this case was already found by another judge, I am loath to disturb that finding. I did review the affidavit, but she has already found probable cause, so I'm not going to change that today. I will set your bond at $15,000. Ms. Shaw, my concern about the out on bond case is it's a driving charge, and this is also a driving charge. I understand his defense is he's saying he wasn't the one driving, but that's
If the court would like to add a special condition of no driving, that would be acceptable.
Your Honor, respectfully, he already shouldn't be driving because he has a suspended license.
right. The court's inclined to revoke it and hold him at no bond. He's out on bond for a driving charge. He's arrested for a new driving charge. So he's shown a pattern of unwillingness to comply with court orders, and because the charges are of the same nature, that's what's concerning to the court. And let me tell you, Ms. Shaw, your client just raised his hand. I think he wants to speak. I don't know if you want to, I know it's over the speaker, but if you want to say something to him before he says anything to the court, you might want to do that.
Yeah, I would just advise you not to speak to the court, Mr. Mills.
Yes, ma'am.
Your Honor, state's main concern is he has at least 2 prior failures to appear, the last being 4 months ago in March of 2022, along with a pretty lengthy criminal history of several driving offenses, several other fleeing and attempting to elude, several other Willis's, prior DUIs, prior leaving the scenes. It seems he has a fairly lengthy criminal history of a lot of driving offenses, drug offenses, and some violent offenses. So it would just bring your attention to that in addition to his recent failure to appear.
You know what case that was in?
The failure to appear?
Yes.
1 second.
I was on a VOP, ma'am.
Oh, that's a VOP?
It was a misdemeanor VOP. They had reset me a court date, and I didn't know about it, and I missed it, but I got it taken care of.
He retained our office and we handled it for him and resolved his VOP, so he's no longer on probation right now.
Yes, ma'am. Your Honor, I'll be at every court date. I'll follow every special condition. I mean, this situation here was just, I was not there at all, period. I was in Tampa from Tuesday of last week until Monday of this week here.
All right, thank you. Any further argument from either of the attorneys on whether I should revoke his bond?
No, and Your Honor, just the fact that his suspended license case is still ongoing right now because I am working with him to get his license. I understand the nature of it is financial at this point. So he was anticipating getting this license back in August. That's the only reason the case has been open this long. Otherwise, we would have resolved it. If he pled to the driving license suspended as is, he'd be habitualized for 5 years. So that's why the state's kind of working with us to keep it open at this point. And as to this incident fleeing and eluding case, he does have an alibi. It is our position that it was not him driving that day in Orlando because he was in Tampa. So I understand the nature of the charge, but we are asking to set a bond on this case and not revoke his bond on the Dwellis's.
Your
All
Honor,
right, anything else from the state?
I believe there's also an additional Dwellis. I have 21 CT 7203, which is a Dwellis that's currently set for a status hearing. And then I have the 2022 CT 717 Dwellis that I believe Ms. Shaw is retained on and is out on bond. So I believe there are
Yeah,
two.
I believe the 21 CT Dwellis was a notice to appear, a criminal traffic violation, so he's not out on bond on that case.
Just bring your attention that there's two open Dwellis's, Your Honor.
No. All right, here's what I'm going to do. I will revoke your bond in your out on bond case. However, instead of holding you at no bond, which I was inclined to do, based on your attorney's argument, I will double the bond that was previously set. Can anyone tell me what that is?
500, ma'am.
It was 500? Okay, so now that bond will be $1,000. And in both of these cases now, your condition of bond is you are not allowed to drive. You understand?
Yes, ma'am, I do.
All right, and stay in touch with your attorney.
Thank you so much, ma'am.
Yes, sir. Good luck.
Thank you, Your Honor. Have a nice day.
And I'm sorry, Ms. Shaw, it didn't tell me you were here, so I thought, well, we tried. So thank you so much for telling me that you were there.
I appreciate it. Have a nice day.
All right, you as well. Bye. Before we're adjourned,
Yes.
this one, did we address it?
Not yet, Your Honor.
Okay, go ahead and call it.
We're just giving the state time to look.
Can you give me the case number again real fast?
Yeah. 2022 CF 704080.
That is Essence Green Jones, and it should be granted notice of non-filing.
Got it. Anything else before court is adjourned?
Nothing from the state.
Nothing from defense, Your Honor.
Court is adjourned.
Public defender.
All right, we'll get started.
Spanish.
And is the Spanish, do I have to hit this? Okay, thanks.
Good morning, Your Honor. This is Ricardo Morales, Spanish interpreter. I have been previously sworn.
Good morning. Could you please ask if the witness also needs the assistance of the interpreter?
¿El testigo que se encuentra en sala requiere el servicio de intérprete?
No.
No? Okay. All right, if you could connect with the headset, please.
Yes, Your Honor. 1 second.
And when they come in, can you just ask them? Obviously not.
Sí.
They need an interpreter.
Sí.
Your Honor, the interpreter can confirm there's connection to the headset. We're ready to proceed.
All right, good morning. Please tell me your name.
Miriela Valdez Betancourt.
Muriela Valdez Betancourt.
Ma'am, you're here in 22 CF 8408, charged with aggravated assault with a deadly weapon, domestic violence, and battery domestic violence. I reviewed the probable cause affidavit. There is probable cause. Sir, do you wish to testify this morning?
Yes.
All right, raise your right hand, please.
Sí.
Or affirm the testimony about to give should be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Please state your name for the record and spell your last name.
Robert Marrero, Marrero.
All right, I'm going to ask the state to ask you questions.
Good morning, sir. Can you please state your relationship to Mrs. Betancourt?
Yeah, she's my wife.
Are you afraid of her?
No.
I'm sorry, go ahead.
What it was is that I had a phone call from work and she thinks I'm having affairs with another woman. That's all what happened.
Has anything like this ever occurred before?
No, ma'am.
If anything like this or anything more severe ever occurred in the future where you felt threatened, would you feel comfortable calling 911?
If it happens again, yes.
And do you believe drugs or alcohol were involved?
What?
Do you believe drugs or alcohol were
No,
involved?
she does not use drugs or alcohol. It's just
And-
a temper. She's jealous. All it is about jealousy.
And do you want to have contact with her while this case is pending?
Yes, she's my wife.
No further questions, Your Honor.
Any questions from the defense? All right, sir, is your last name Suarez also?
Suarez, Roberto Marrero Suarez.
All right, thank you very much. All right, ma'am, at this time, your bond will be $5,000 on count one, $100 on count two. With special conditions, you can have peaceful contact only with the victim. Do you understand what peaceful contact means?
No.
No.
No yelling, no raising your voice, no hitting, no shoving. You can't use any weapons at all. You can't possess a weapon of any kind. Any other conditions the state would request?
Hey, Your Honor.
All right, good luck, ma'am. Thank you for coming, sir. Good luck.
Thank you, ma'am. Appreciate it.
Is that all we have for the Spanish interpreter? At this time, thank you so much.
May the interpreter be excused, Your Honor?
Yes,
Thank you, Your Honor. Have a good day.
you as well. This is Judge Gibson. Can you hear me?
Yes, I can.
Who do I have on the line?
My name is Gailin, ID 250762, Haitian Creole interpreter for Language Line Solution.
Has the interpreter been sworn?
No.
Please raise your right hand to be sworn.
Do you swear to translate from Creole to English, English to Creole, testimonies given?
Yes.
All right, please ask him to raise his right hand.
Levez mes doigts tout.
Do you swear to Do you swear from the testimony you're about to give, should be the truth, the whole truth, and nothing but the truth?
Est-ce que ou d'accord que témoin et ou juré que témoignage ou pas le bail c'est vérité, c'est pas l'autre bail que vérité, c'est vérité.
He said yes.
Yes.
Sir, please tell me your name. You can put your hand down.
Mettez mon descend mon qui j'en relais.
Smith.
Smith Toussaint.
Sir, you're here. It looks like only on the violation of probation. The allegation is that you violated your felony probation by committing a new law offense of attempted burglary of an occupied conveyance.
Occupy what, Judge?
Conveyance.
Les deux comme ça que semble que au violé et crime côté fait au fond l'autre et offense loi parce que ou t'as volé dans une convence.
At this time, there is no bond.
Pour qu'on y a pas aucun yo pas aucun bon yo pas ba ou.
Do you know if the public defender's office was appointed in his other case?
Yes, Your Honor, we were.
Sir, do you wish to have me appoint the public defender's office in this case as well?
Est-ce que vous voulez pour me mettre un défenseur public sous casa tout? Judge, I cannot hear him. Is he speaking?
I can't tell. Please get closer to the microphone.
Monsieur, Abbas.
But allez see voler mes amis.
I didn't go and sell anything.
Yeah, didn't but allez see voler yo bam cool.
Madam Interpreter, could you please advise the client not to go into the facts of the case? He's here for the violation of probation.
Ok, monsieur, puis go aller dans détail, ça passe, ou là pour violation, sorte faire.
Sir, the only thing we're here for today is to address this violation of probation. There is probable cause for that.
Ok, monsieur, sel bagay nou la, se paske ou viole probasyon, gen cause probable pou sa.
I'm not saying you're guilty of anything.
M'a di ke ou coupable de rien.
My question to you is, do you want to be represented by an attorney in your violation of probation case?
Kesyon mwen gen pou ou an, se esko vle pou yon avoka reprezento nan kar violasyon lan?
Yes, yes, yes. Okay.
Okay, he said.
He said yes, yes, and then okay.
All right, at this time, I will appoint the public defender's office provisionally based on the fact that you were appointed in the new law.
I'm sorry, like, Judge, he was speaking while you were speaking, like.
What did he say?
I don't know because you both were speaking at the same time.
Go ahead.
Okay. Do you want him to speak now because he kept speaking while we're speaking?
Yes, what is it you want to say?
Mdi kon sa map chèche yon avokat, oui, map chèche yon avokat pou mède sou kes sa, kon nou di vale.
Okay, I'm gonna seek a lawyer to put on the case since you say I violate.
All right, so you're going to hire an attorney yourself?
Okay, est-ce que c'est ou même qui paye et a employé un avocat, payer un avocat ou bien qui sont décidés?
Yeah, in this case, I got to do it. What I got to do? Because he didn't do nothing. Yeah, I got to put my home on him. Yeah, I got to get a good lawyer.
All right, sir, do you have the money to hire an attorney?
Even if I don't have one, I'm not going back to jail. Man, come on.
All right, then I'm not going to appoint the public defender's office in the VOP. Good luck, sir.
Thank you.
Thank you. Always something, man.
Okay, anything
I
else?
believe that's all
Judge?
we have for the Creole interpreter. Thank you so much.
Thank you for using our service. Take care. Bye-bye.
Shannon Dwayne Taylor.
I'm sorry, tell me one more time.
Shannon Dwayne Taylor.
Mr. Taylor, you're here in a case I don't have, a case number. Charged with violating your probation. The allegation is that you committed a new law violation of possession of a controlled substance, grand theft, and resisting without violence. At this time, there is no bond authorized on that warrant. Sir, do you wish to be represented by an attorney?
Yes.
Do you have the money to hire a lawyer?
How much?
That's up to you and an attorney.
Oh, I wanna.
I'm sorry? Did he?
He fill up. Yeah.
All right, I'll appoint the public defender's office for now. Am I supposed to be doing this?
You're a violation of probation.
No one's been doing it? All right. All right, good luck, sir. I'm less worried about it then.
It's Andrew Tony Ware.
Good morning, sir. You're here charged with attempted burglary of a structure. I'm sorry. I think you're here on the violation of probation, which the allegation is that you violated your probation by committing the attempted burglary of a structure.
Okay.
At this time, there is no bond authorized. Do you wish for me to appoint the public defender's office?
Not really.
All right, you can hire your own attorney.
No, I just want to represent myself.
All right, you're going to represent yourself?
Yes, ma'am.
All right, you understand that if you represent yourself, you could be at a disadvantage.
Right.
The state of Florida is represented by an attorney who went to law school, who practices law.
All right.
But you want to represent yourself at this time?
Yes, ma'am.
Sir, do you have any history of mental health issues?
No, ma'am.
Are you under the influence of any drugs or alcohol today?
No, ma'am.
You don't appear to be. You appear to be alert and intelligent, capable of understanding what's happening. So at this time, I'll not appoint the public defender's office. All right, good luck, sir. Did I say no bond? Okay.
Jose Torres Velez.
Good morning, sir. You're here in 22 MM 4843, charged with battery domestic violence. There is probable cause. Sir, do you wish to be represented by an attorney?
A public defender.
So are we not doing the, he qualifies? All right, are you just gonna tell me if they don't? Great. All right, I'll appoint the public defender's office to represent you. Did you wish to be heard on bond?
Your Honor, State would just ask for a reasonable bond.
The defense?
Your Honor, I would just, it looks like he qualifies, right? Unless I'm looking at,
No, he didn't qualify.
he didn't, okay.
You
I'll just
refused
ask
to
for.
talk to them.
Mm-hmm.
Why was it reset?
What was it? Behavior?
It was a behavior, but I don't know why it wasn't waived. I don't know.
I tried to waive it, but he said he needs to appear for court, Your Honor.
All right, hold on, I gotta set his bond.
I do see he has an active Osceola bat DV as well.
I was wondering about that, so wouldn't this
Oh, I was looking at
affect
Sharp.
that?
I was looking at Sharp, that's why.
What's that feedback? Did y'all hear the feedback? It says that you're out on bond, sir, for committing a battery, domestic violence on the same victim. I'll leave that bond undisturbed because that's not in front of the court at this time. However, based on that, in this case, sir, your bond will be $2,000. With special conditions, you can have no contact with the victim. Do you understand what no contact means? I can't hear you.
Don't do anything with them.
I still can't hear you.
Don't even look at them, pretty much.
Right. You cannot speak to her. You cannot send a message through friends or family. You cannot contact her on social media. You cannot be within 1,000 feet of her residence or her place of employment. Do you understand that? You cannot possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir.
Corey Collins.
Mr. Collins, you're here in 22 CF 843680, charged with battery and tampering in a misdemeanor proceeding. I reviewed the probable cause affidavit. There is probable cause here. I'll appoint the public defender's office to represent you. Does either side wish to be heard on bond?
No, Your Honor.
Just ask that you set a reasonable bond.
They would just ask for normal conditions and a reasonable bond, taking into account he has 2 prior failures to appear that seem to be relatively recent.
All right, at this time, your bond will be $100 on count 1, $2,000 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You cannot possess a weapon of any kind, a firearm or any ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand? Good luck.
Your Honor, ED is a refusal.
All right, hold on one moment. I don't have that case number. 22 CF 8437. I will find her refusal a willing waiver of her appearance today in court. I reviewed the probable cause affidavit, and there is probable cause here. She did not complete the PD form.
She did it, Your Honor, however, on her out on bond, we are appointed, we already filed our motion to believe she's incompetent, so I just ask that you appoint us to the new law based on that, and we'll get the financial affidavit filled out.
All right, I will, based on that. Thank you, Counselor. Appoint the public defender's office. You filed something in the out on bond case about her competency?
Yes, March 31st of this year, Your Honor.
All right, then I will not revoke that bond. I'll set bond in this case, however, I'll set a monetary bond, but depending on what y'all do with that, and if you, we can always readdress that.
Yes.
It'll be $1,000 on count 1, $100 on count 2, no weapons, firearms, or ammunition, maintain separate residence, one-time return, and no contact with the victim.
So you took no action?
I'm sorry?
You took no action?
Yeah, no action on the out of bond. I feel like I need
Aaron
this.
Terrell Ivy Jr.
All right, Mr. Ivy, you're here in 22 CF 8438, charged with burglary of an occupied dwelling, petty theft, criminal mischief, and battery dating violence. I will appoint the public defender's office to represent you. There is probable cause here. Counsel, did you wish to be heard on bond?
Your Honor, I would just ask that you consider when setting the bond that he has no failure to appear. And it looks like the convictions that I see is only a resisting without violence. So I'd ask that you consider that when setting the bond in all of his cases.
Your Honor, so just ask that you take into account, he does have several other bat DV arrests, and I believe the latest, there was a 2022 non-arrest misdemeanor bat DV, victim being Miss Moore, the same victim in this case. He had a 2020 misdemeanor bat DV, victim being a different victim, his brother, Mr. Anderson. He had another battery ag-bat pregnant person from 2020. Victim being Miss Moore, the same victim in this case. He had a 2017 misdemeanor bat DV. Victim being his mother, Mrs. Anderson. And then there's a few that are older, like 1997. No, that's senior. So that's all I have for Mr. Ivy Jr., Your Honor. I believe all of those, the victim was unwilling to prosecute. However, it just shows the continued behavior between this victim and this defendant.
Thank you. If I could get both of you to aim your microphones at you. 'Cause yours isn't either, Miss George. Yeah,
Okay.
It helps me be able to hear you. All right, Mr. Ivy, at this time, your bond will be $5,000 on count one, $1,000 on count two, I'm sorry, $100 on count two, $100 on count three, and $100 on count four. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, a firearm or ammunition. You cannot return to the victim's residence for any reason or be within 1,000 feet of her residence or place of employment. Any other conditions the state would request?
No, Your Honor.
Good luck, sir. Need it to punctuate the end of the case. It's not funny, like my brain needs the. I can't hear you, ma'am.
Sherelle Monique Metwater.
Ma'am, you're here in 22 CF 8053. A warrant was issued for your arrest, charging you with aggravated child abuse, and neglect of a child. Another judge has already found probable cause in this case. I will appoint the public defender's office to represent you. Is she entitled to bond in this case?
Yes, Your Honor.
What says the state has to bond?
Count one is just an F1. So state would ask that you set a reasonable bond. Given the allegations within the affidavit and that there were two children involved, I believe it was an 11-year-old and a 5-year-old. And a lot of the allegations were by one child was corroborated by the other child. State would just ask that you set a reasonable bond. I believe she's charged with an F1 and then 2 F3s. So state just ask that you set bond respectful of those degrees of felonies, Your Honor, since they are serious offenses.
All right, what says the defense?
Your Honor, I just ask that you consider that she has no criminal history, been in the area for over a year, so I just ask that you consider that when setting the bond.
At this time, ma'am, your bond will be $25,000 on count one, $5,000 on count two, and $5,000 on count three. With special conditions, you can have no contact with the victims or any witness in this case. Do you understand what no contact means?
Yes.
You can't have contact with any minor child under the age of 18. You must comply with any plan set in place by DCF. You can't possess a weapon of any kind, a firearm or ammunition. Any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am.
Dorian Rafael Romero.
Good morning. You're here in 22 CF 8392, charged with aggravated battery on a pregnant person, domestic violence. There is probable cause. PD? I'll appoint the public defender's office to represent you. Does either side wish to be heard on bond?
Your Honor, I just point to the fact that although he has a history, he has no failures to appear, so I ask that you consider that when setting bond.
Your Honor, yes, state would also just, it does look like he is a career offender, with a pretty lengthy criminal history. And within the allegations of the affidavit, it does appear that this was a second incident that the victim's reporting. She reported one that occurred approximately 2 weeks prior as well. So state would just ask that you take that into account when setting his bond.
I do see your criminal history, the gang affiliation, the Florida career offender. Can you tell, did he go to prison? Was he in DOC for that?
He has 3 DOC incarcerations, Your Honor.
Was one of them from 2014?
Not too sure. I just see that his last one, he was released in 2017.
2017? All right, thank you. All right, your bond in this case will be $10,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. Were you two living together?
Yes, ma'am.
You cannot now. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes, ma'am.
Good luck. Thank you.
Jason Wilburn.
Mr. Wilburn, you're here in 22 CF 8435, charged with aggravated battery, domestic violence. There is probable cause. I'll appoint the public defender's office to represent you. Does either side wish to be heard on bond?
Your Honor, I just point to the fact that his last conviction was in 2008. He has no failures to appear and community ties. He's lived in the Orlando area for well over a year.
And Your Honor, state would just bring your attention that the reason for the aggravation is the alleged use of a box cutter. And I believe there was also alcohol use on both the victim and the defendant, so state would ask for that as a condition.
All right. At this time, your bond is $10,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Ma'am.
You cannot possess a weapon of any kind, firearm or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You cannot possess or consume alcoholic beverages. You'll be subject to random alcohol screens. Do you understand?
Yes, ma'am.
All right, good luck. Thank you.
Judge Richard Kramer.
Mr. Kramer, you're here in 22 MM 4845, charged with battery, domestic violence. There is probable cause. I'll appoint the public defender's office to represent you. What are these other fugitive warrants? Those are not here.
They're not sitting IAs, Your Honor, no.
All right. Does either side wish to be heard on bond?
Your Honor, state would just ask for a reasonable bond. Given it doesn't appear Mr. Kramer has much Florida history, however, it does appear that he has a lot of out-of-state history. State's concerned regarding his community ties. And given the fugitive warrants, state's concerned about his ability and willingness to come back to court. State would ask that you take that into account when setting his bond.
I share that concern. What says the defense?
It's that you set a reasonable bond, Your Honor.
All right, thank you both. At this time, sir, your bond is $10,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir.
Thank you, ma'am.
Thank you.
Good morning, guys. My name is Romance Faircloth.
Mr. Faircloth, give me one moment. You're here in, is he here for both, the CT and the MM?
Correct.
All right. 22 MM 4867, You're here charged with battery, domestic violence, and resisting an officer without violence. There is probable cause. Sir, you don't qualify for the appointment of the public defender. Do you wish to be represented by an attorney? All right, you're gonna have to hire one.
I'm not gonna do it myself.
All right. Does the state wish to be heard on bond?
Your Honor, state was just asked for a reasonable bond, taking into account a recent failure to appear and other prior bat DV arrests and violent arrests.
I see all of that. In your other case, you are here on a failure to appear, sir. At this time, your bond will be $5,000 on count one, $1,000 on count two. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
No.
You cannot possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. In your 22 CT 274 case, you're here because you failed to appear for court. The bond on that is $2,000. Good luck, sir.
Your Honor, short is medical.
22 MM 4853. I am going to appoint your office, Ms. George.
Huh? He doesn't, he has to hire a private. I will waive the appearance, Your Honor, and also point to the fact that he does qualify for pretrial release. In this case, he has no failures to appear, and the last conviction was in 2015 for resisting without violence. So I'd ask for pretrial release in this case.
All right, what says the state?
Your Honor, state's main concern is Mr. Sharp has a fairly extensive bat DV history. This case, a 2021 misdemeanor non-arrest bat DV, victim being Mr. Hampton, 2015, 2014, 2009, 2008, 2007, 2006. State will leave it within your discretion, however, state is concerned regarding his extensive bat DV history.
I only see one conviction, correct?
Are those arrests or convictions?
They were arrests, Your Honor.
Right.
Yes.
I believe there was one, I see at least one battery that he pled no contest to in 2009, however, it was not DV related.
And Your Honor, he's on social security disability, so if you do, pretrial release with a small monetary bond, I think that would, help.
I will, and I'm looking at his conviction history. You don't see it keeping a house of ill fame that often.
No.
Just, that's an unusual conviction to see. All right, I'll place him on pretrial release, require that he post a monetary bond. However, I will reduce that amount to $500. With special conditions, he can have no contact with the victim, no weapons, firearms, or ammunition, maintain a separate residence, one-time return with law enforcement.
Marie Vega.
You're here in 22 MM 4856, charged with battery and domestic violence. There is probable cause. She did not complete the affidavit for a public defender. Ma'am, do you wish to be represented by an attorney?
I didn't understand what.
I can't hear you. Get close to the microphone.
I didn't understand what the paper mean, so I never.
Okay, so you're here charged with a crime. You have the right to be represented by an attorney. If you cannot afford to hire an attorney, I can consider appointing one to represent you if you qualify. But you have to complete a financial affidavit to apply for that. So do you have the money to hire an attorney? You have to answer out loud.
No.
All right, I need you to complete the affidavit. Do you have a job?
Well, I'm a dancer. I'm not like a 9 to 5, but just I work for tips.
All right, how much money do you make?
A week or
However often, a week, a month?
probably like 1,000 or so. 1,000.
A week?
Yeah.
Yeah.
All right, so you're not gonna qualify for the public defender's office? I'm not gonna appoint your office. It doesn't look like she qualifies. You can still fill out the affidavit, but I don't think you qualify. So I think you're gonna have to hire your own attorney.
And Your Honor, state has no objection to PTR.
All right, what I'm going to do is place you on pretrial release in lieu of posting a monetary bond. I'll require that you post a reduced amount of $100. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. But if I were you, I would try to hire an attorney right away before your next court date. You understand? You have to answer out loud.
Yes, yes.
All right, good luck. I can see your head nodding, but the record doesn't see that. Good luck. There are a ton of out-of-counties today, a ton.
Marcus James Bamer.
All right, Mr. Bamer, you're here in 22 MM 2801. It looks like you have a warrant out of Lake County for obscene or harassing phone calls, domestic. At this time, there's no bond authorized. We'll notify Lake County that you're here, and they'll transport you in the next few days. All right, good luck, sir. Ms. George, when I left, your office was asking us not to appoint you guys on the out-of-county cases. Is that still your office position?
Yes, Your Honor.
Okay,
Thank you.
unless there's a reason.
Yes, Your Honor.
Your Honor, do you have Bostrom next?
I have Dixon.
Okay, okay. He's here, present.
John Dixon.
Mr. Dixon, you're here in 21 CF 3957. Looks like you have a warrant out of Seminole County for failing to appear on a charge of stalking. The bond authorized on that is $500. We'll notify Seminole County that you're here so they can transport you, or you can post that bond if you're able to. Good luck, sir.
Keisha Leon Richardson.
Mr. Richardson, you have a writ of bodily attachment out of Volusia County. The purge amount on that is $570. It looks like it's for child support.
I've been paying every week.
I'm sorry, I believe you, but there's nothing I can do about it. It's out of Volusia County. So you have to go back to Volusia to address it. You can pay it here and get out, or you can go back to Volusia County, but I can't change it because it's not, I don't have jurisdiction over it. Sorry, good luck, sir.
Maria Stadler.
Ms. Stadler, you're here for warrants out of Osceola County, 22 MM 1421. It looks like the charge is battery domestic violence. There's no bond authorized, but you have special conditions of no contact with the victim, no weapons, firearms, or ammunition, and no return to the scene. We'll notify Osceola County that you're here so they can transport you. Good luck.
Daniel Allen Baker.
Mr. Baker, you're here in 20 CF 9069. Looks like a warrant was issued for your arrest for violating your probation. The allegation is that you failed to report. There's no bond authorized at this time. I'll appoint a public defender to represent you. Good luck, sir.
Nicholas Allen Houseman.
Mr. Houseman, you're here for violating your probation. A warrant was issued for your arrest in 17 CF 6312. The allegation is that you changed your residence without first procuring the consent of your probation officer. The bond authorized is $5,000, and I'll appoint the public defender's office to represent you.
Can I get that lowered by any chance or no?
Not today. Good luck, sir.
Morning, I'm Gina Louise Lucan.
Good morning, ma'am. You're here in 19 CF 16320. A warrant was issued for your arrest for violating your probation. The allegations are that you failed to report as directed, you failed to complete your community service hours, you failed to complete the impulse control class, and you had a positive drug test. At this time, there is no bond authorized, and I'll appoint the public defender's office to represent you. Good luck.
Ryan Fury Morrow.
Sir, you're here in 20 CF 597. A warrant was issued for your arrest for violating your probation. The allegations are you failed to report as directed, and you failed to complete the batterer's intervention program. At this time, there's no bond authorized, and I'll appoint the public defender's office to represent you.
Curvins Pierre.
Sir, you're here in 21 CF 12649. A warrant was issued for your arrest for violating your probation. The allegations are that you changed your county of residence and you left the county without permission. There's no bond authorized at this time, and I'll appoint the public defender's office to represent you. You want to talk to them about any defenses you have. Yeah, you're going to go that way, but you're going to talk to your attorney later.
Oh, okay, I'm sorry.
It's okay. Yes, good luck.
Ronald Postel.
Sir, you're here in several cases for violating your probation, 20 CF 14377, 19 CF 14793, 21 CF 594. The allegations are you failed to report as directed, that you failed to complete your recommended treatment, that you moved. There's no bond authorized on those cases. I'll appoint the public defender's office to represent you. And then in 21 CF 8368, a capias was issued for your arrest for failing to appear on a charge of sale or delivery of a controlled substance. There's also no bond authorized on that, and I'll appoint the public defender's office in that case as well. Good luck, sir.
Moises Rodriguez Jr.
20 CF 14294. A warrant was issued for your arrest for violating your probation. The allegations are that you moved, that you failed to undergo the mental health evaluation as ordered, that you failed to complete anger management. At this time, there's no bond authorized, and I'll appoint the public defender's office to represent you. Good luck, sir. What about it? Okay. Give me one moment. What division are we, Mr. Watson?
82, Your Honor.
82. Thanks. All right, is the state ready for the 3-day motions?
Yes, Your Honor.
Am I doing this first? What? Okay. Oh, that's the motion. Oh, thank you. All right. I have Davis first. Is that who you have?
No, but we can go with it. That's fine.
Okay.
Sean Davis, 22 CF 6487, denied and information was filed. Joseph Fields, 22 CF 5621, granted, it was no billed. Carlos Garcia, 22 CF 6941, granted, notice and on filing. Stefan Holbrook, 22 CF 4666, denied and information was filed. Jaleel Williamson, 22 CF 7033, granted, notice and on filing. Marvin Hill, 22 CF 7063, denied and information was filed.
Wait. Who was that?
Hill.
Hill, okay.
Victor Cordero, 22 CF 7098, granted, notice and on filing.
Wait, was Hill granted or denied?
Denied, and information was filed.
Hold on a second. You might have to submit a new order, Ms. George. I messed that one up.
Oh.
For Hill. I'm sorry,
Am I going
my
too
paperwork
fast?
was in a different order and I got lost. Okay, go ahead with Cordero.
Cordero, granted, notice and on filing. Green Jones, 22 MM 146, granted, notice and on filing. Rule 22 CF 6944, granted, notice and on filing. DeLilly 22 CF 6712, granted, notice and on filing. Lovesmith 22 CF 7076, granted, notice and on filing. Fulbrook 22 CF 5598, granted, notice and on filing. Rios Ramon 22 CF 7000, granted, notice and on filing.
Hold on a second, please. Go ahead.
Rios Roman 22 CF 6994, granted, notice and on filing. Allen 22 MM 4551, denied and information was filed. Harrison 22 MM 3417, denied and information was filed.
Harrison, what was that?
Denied and information.
No, what's the case number?
3417.
That's the bond motion. That's not a 33-day motion.
I have it on the 33-day list as well, Your Honor.
Okay, hold on. We'll get back to that one.
And then I have King 22 CT 2905, and that was filed by UTC.
I had one that was reset today. It was.
All right, so
Date.
Harrison is the bond motion Mr. Wasson filed.
Green Jones.
Different case number.
Yes, Your Honor, I don't believe I filed a 33-day motion.
I don't know.
On my case at least. He does have other cases, Your Honor. It's possible that another one is the issue.
Okay. Well, she has your case number, but you did not file a 33-day bond motion. Okay, so let's address your motion, Mr. Wasson.
Your Honor, before we move to the motion, I had one 33-day motion that the judge yesterday reset just for today, only because of the 33rd day was today. So he just reset it for this morning. It's Essence, case number 2022 CF 7040 AO.
You have an order?
I still have the order on this one from yesterday. The other two I'm gonna have personally reset, but since this one was only reset for yesterday.
Can we move it to the second session?
Yeah, not a problem.
Thank you.
We'll move it to second session so she has a chance to review, Your Honor.
Okay, we can do that. Thank you. All right, Mr. Wasson, go ahead and call your case.
Mr. Hanson Harrison, 22 MM 003417 AOR.
Go ahead.
Yes, Your Honor. So this is going to be a motion, a bond motion for Mr. Mr. Harrison. I apologize. Mr. Harrison was previously being held on a burglary on this in this matter. It was transferred to the misdemeanor division as a trespassing. He still has no bond on his trespassing charge. In addition, he's still being held on the burglary that was transferred to this case, Your Honor. Mr. Harrison would ask for reasonable bond be set in his trespassing case. In addition, would ask for him to no longer be held on that burglary charge.
All right, so everyone is entitled to bond on a burglary charge. He should not be held at no bond on a burglary.
Yes. Well, I don't know why he was held at no bond on the burglary, but the issue is that he's being held at no bond on this trespass, Your Honor. I can't speak to why he was being held at no bond on the burglary.
Well, it looks like the.
It was revoked.
It was revoked.
It was an out on
Burglary
bond, Your
charge
Honor, and
was
revoked, so he's not entitled to bond, so state would object to bond being set.
Okay.
So that's why I said it's not as simple as it looks.
Okay.
Because you have to get to why he's being held at no bond.
Right.
You're entitled to bond on a burglary. So if he's being held at no bond, it's probably not because it's a burglary. He's being held at no bond because his bond was revoked. Why was his bond revoked?
Out on bond.
I believe it was revoked, Your Honor. No, is that? I believe it was revoked for picking up another criminal mischief case. I believe it was 22 CF 5238, which was a burg occupied petty theft criminal mischief as well, so the similar charges.
I did it at IA's.
Uh-huh. On May the 11th. You revoked that case.
So he picked up substantially similar charges, and he was on bond for the same charges.
All right, so at this time, Mr. Wasson, I'm inclined to deny your motion. I don't think it has in it what I need. Your client's bond was revoked apparently by this court for being out on bond while committing a substantially similar new offense.
Yes, Your Honor.
You understand that by doing that, you're no longer entitled to bond.
Yes, Your Honor.
So unless you're going to present some evidence or something for the court to consider, at this time, I'm going to deny your motion.
I have no further evidence, Your Honor.
All right, I'll deny it at this time. You can always refile it, Counselor.
Yes, Your Honor.
All right, was there another one?
Yes, Your Honor. Joseph Zane Allen, case number 22MM004551AO.
Wait, I need you to tell me that case number one more time.
Yes, Your Honor. 22MM004551AO.
All right, go ahead, counsel.
Yes, Your Honor. I'm sorry, give me 1 second. Let me pull up the. Yes, Your Honor. So in this case, Mr. Allen is being held on petty theft charges. He would request that the bond be reduced. He's currently being held on $2,000 bond. He would ask the bond be reduced in this matter so we could post bond, or the alternative, it would be released on own recognizance. He has been in on this charge since the 4th of last month, Your Honor. There's a considerable amount of time for a petty theft charge.
What? This is a separate motion. Counsel, did you put in your motion the amount of bond?
Unfortunately, Your Honor, I'm seeing I did not.
And did you put the amount of bond that you're requesting?
No, Your Honor, I did not, unfortunately. He's currently being held on a separate petty theft charge at $150. That would be the amount that I would request, Your Honor.
So how did we do that? Did we already call that case? Okay, so we called this as a 33-day motion. And I denied it. I see. All right, so you're asking the court to do something vague based on no evidence at all?
Your Honor, state would ask for the bond to be stayed as is. I believe the reason for the $2,000 bond on a petty theft is he has a 2022 petty theft out of Duval that was a withhold on April 28th. He also had a 2022 petty theft out of Orange that was adjudication. He then subsequently, about a month later, picked up the charges for this case, the 22 MM 4551, that originally came in as a petty theft 2 prior and conspiracy to deal in stolen property, and we ultimately filed the petty theft of 100 or more. So this is his third theft offense in 3 months. But the other two that have already been disposed of with a withhold and adjudication, so state believes that a $2,000 bond is reasonable at this time and would ask that you stay it as set.
Mr. Wasson?
Your Honor, I would just say that Mr. Allen is unable to post a $2,000 bond. He intends to do better if he's released. His time in jail has made him have a different outlook on the realities of his life, and he hopes to get out and do a little bit better.
Does he have any violent offenses?
Do you have any evidence for the court to consider?
Let's see. Can we have a moment, Your Honor?
I would also say, Your Honor, that Mr. Allen has no violent offenses. The state is correct that he has participated in theft in the past. However, this is a matter of survival. In reality, he can't afford to live the way he needs to. He is seeking help for that, Your Honor, and he hopes to do better if he's released.
And I believe social services is going to try to work with him, Your Honor, in order to help with his financial situation. We have an amazing social services program that can help if he's able to get out, maybe help him get a job, employment, to where he's not continuing to pick up more petty thefts if he's given that opportunity. If he does in fact violate the law again, at which point, Your Honor, he's been given ample opportunities to do right, and he could be held at no bond, Your Honor, for picking up the new law.
All right, thank you. All. Do you have an order, Counselor?
I believe I filed an order, Your Honor.
It's not in the court file.
You have to email it to Taylor so she can print it. Okay. Taylor, yep. So T Flynn.
Here's what I'm going to do. I looked at the felony case. It came in originally as 3 separate felony charges. It was remanded and the state filed 1 misdemeanor charge. So based on that, I will reduce the bond. It'll be $1,000 with the same conditions. But Counselor, I need you to submit an order. The one that I had, that I previously signed for the 33-day motions, we're not going to file that one.
I was gonna forward it to Ms. Fleming so she could print
Okay.
for you. So T. L E M.
All right. Anything else before we recess for next session?
Nothing from the state, Your Honor.
.org. Nothing from defense, Your Honor.
All right, let's recess and then discuss.
And I don't think we have a case number yet.
22 CF
2055, got it. 22 CF 2055. Can you ask the defendant if he can hear you, please?
Caballero, ¿usted nos escucha? Yes.
Okay. Please say your name, sir.
Por favor, dígame su nombre, caballero. What?
Your name.
Su nombre. My name?
Yes, say your name.
Sí, dígame su nombre. Wilson Ramírez.
Okay, so for those of you who weren't involved in the last couple of days,
Para ustedes que no estuvieron involucrados los últimos 2 días,
we've had a little bit of difficulty trying to get Mr. Ramirez identified.
hemos tenido cierta dificultad en poder identificar al señor Ramírez.
And so we were hoping to get in touch with his family. I guess he was hoping to get in touch with his family in New Jersey.
Y estábamos tratando de contactar, bueno, él tenía esperanza de contactar a su familia en New Jersey.
And the public defender was attempting to get help by his, un momento, señor, getting help from his wife.
Y el defensor público estaba intentando conseguir ayuda por parte de su esposa.
So they gave me some paperwork today.
Me han dado una documentación en el día de hoy.
Mr. Ramirez, what's your date of birth?
Señor Ramírez, ¿cuál es su fecha de nacimiento? 1978.
Tell me again.
Dígame una vez más. 1978.
Where were you born?
¿Y dónde nació usted? What?
Where were you born?
¿Dónde nació usted? Oh, Honduras.
And what's your mom's first name?
¿Y cuál es el nombre de su madre?
María Magdalena.
María Magdalena.
Okay, so this is a birth certificate for a child, not his birth certificate.
Entonces esto es un acta de nacimiento para una criatura, pero no es el acta de nacimiento de él.
What's your child's name?
¿Y su hijo, cómo se llama?
El varón se llama Andrés Ramírez Lizama.
The boy's name is Andrés Ramírez Lizama.
Okay. These are all social security cards for other people.
Estos son tarjetas de seguro social para otras personas.
There's a card here for Leslie,
Hay una aquí para Leslie,
one for Alexander,
otro para Alexander,
one for Ezekiel.
uno para Ezequiel.
I have the birth certificate for Andres
Tengo el acta de nacimiento para Andrés,
that lists Wilson as the dad,
que indica que Wilson es el padre,
and then a social security card for Andres.
y una tarjeta de seguro social para Andrés.
None of this proves that this is the guy who's standing in front of me.
Nada de esto me comprueba a mí que este es el caballero aquí enfrente de mí.
Okay, are you his wife?
¿Usted es la esposa?
Okay, can you
I have
come
a
up?
wife.
Yeah, she's here. Ella
Yes.
está aquí, un momento.
No casado, pero
Ella se, well, we're not married, but she's my wife.
Okay. Hi.
Hola.
What's your name?
¿Cómo se llama? I'm sorry, Honor, is the interpreter interpreting for this witness as well?
I think so. Do you speak English?
¿Usted habla inglés?
Sonia Lizama.
Sonia Lizama.
Yeah, she doesn't speak English. She shook her head no. Okay.
Your Honor, if I could instruct the defendant to please not speak at the same time as the
I
witness.
don't think he understands what we're doing, but yeah, if you can explain that to him, that'd be great.
Certainly, Your Honor. Caballero, por favor, no hable en este momento que le estamos dirigiendo la palabra a Sonia.
Because she's here in the courtroom with me.
Ella se encuentra aquí en la sala con la juez.
All right, so give me 1 minute.
Por favor, permítanos un momento.
Okay, so ma'am, you are his wife?
Señora, ¿usted es la esposa de él?
No estamos casados, pero sí es mi pareja.
We're not married, but he's my partner.
Okay, and you have at least one child, if not more, children together.
Y tienen como mínimo una criatura, si no más niños en común juntos, ¿verdad?
Lo que pasa es que a mí se me olvidó sacar las copias de los otros hijos, pero solo tengo un hijo en común con él.
What happened is I forgot to get copies for the other children, but we only have one child in common.
Yeah, I don't need the copies for the other kids. It's okay.
No necesito las copias para los otros niños, está bien.
What I'm trying to do is to prove that he is who he says he is.
Lo que estoy tratando de comprobar es que él es la persona que él está diciendo que es.
Now, you gave me a birth certificate that has his name as the father for a child named Andres.
Usted me dio un acta de nacimiento que tiene el nombre de él como padre para un niño que se llama Andrés.
And that's fantastic. Congratulations, it's a boy.
Felicitaciones, que él es un niño y es Andrés.
But this piece of paper doesn't say that the man standing at the jail is Wilson.
Pero este documento no me ayuda a comprobar que la persona parada enfrente de mí ahí en la cárcel es Wilson.
So now I'm sure that this is going to get resolved very quickly, but imagine if I let him out because he told me he's Wilson and God forbid something really horrible happens.
Pero esto se va a poder resolver rápidamente, pero imagínese usted si yo le acepto lo que me está diciendo que él es Wilson y yo lo dejo salir de la cárcel y algo horrible fuese a suceder.
And then the news is going to say, Judge let this crazy person out of jail and he committed all these crimes.
Entonces los noticieros van a decir, la juez dejó salir de la cárcel a esta persona loca y cometió todos estos delitos.
I have to know who I'm talking to by proof.
Yo tengo necesidad de tener comprobante para poder saber quién es la persona con quien estoy hablando.
I don't want you to stay in jail a minute longer than
Yo
you
no
have
quiero
to.
que usted tenga que permanecer un minuto más en la cárcel que lo necesario.
But I cannot release you until I can confirm your identity.
Pero yo a usted no lo puedo liberar hasta que yo no pueda confirmar su identidad.
Now I'm going to talk to the lady again.
Y ahora voy a hablar con la señora de nuevo.
He said that he has his mom and some family in New Jersey.
Él me dijo que él tiene su mamá y otros familiares en New Jersey.
Is it possible that you could communicate with them and see if they have anything with his name and his photo?
¿Usted cree que usted se pudiera comunicar con ellos a ver si ellos tienen algo que tenga el nombre de él al igual que una foto?
Le voy a llamar a la mamá a ver si tiene algo para él.
I'm going to call his mom to see if he has something for him.
They can email it or fax it to you and you can give it to pretrial release.
Se lo pueden enviar por correo electrónico o por fax y usted se lo puede dar al Departamento de Libertad Provisional.
It could be anything, even if it's expired.
Puede ser cualquier documento aún si ya está caducado.
Like maybe an old license or an old passport.
Por ejemplo, una licencia de conducir antigua o un pasaporte antiguo.
But something official that has his photo and his name.
Pero un documento oficial que porte el nombre de él al igual que una foto.
Okay. Sir, what were you going to say?
Caballero, ¿qué iba a decir?
Una pregunta, que me le haga a la mujer que me busque una copia del pasaporte en un closet y en las cosas mías.
I have a question to ask the lady to get me a copy of my passport in the closet amongst my things.
Perfect. She's here. She's listening. She's going to go home and look for it.
Perfecto. Un momentico, señora. Perfecto. Ella está aquí, está escuchando y lo va a ir a conseguir.
Que ya lo busqué y no encontré nada. Lo que encuentro son cosas de Western Junior.
I've already looked for it and I can't find it. All I'm finding is stuff from Western Union.
Okay, well, do your best, see what you can get from his family, and let us know the minute you find anything.
Bueno, haga su mejor labor, contacte a la familia a ver si puede conseguir algo y déjenos saber tan pronto lo consiga.
Okay.
Okay? So he's gonna get reset, and hopefully we'll get some more info.
Vamos a aplazar el caso y tenemos esperanza que consigamos una información adicional.
And as I told the public defender the last couple of days, this does not prevent you from filing whatever motions you feel are appropriate in front of the judge who has the case.
Y como le dije al defensor público estos últimos 2 días, esto no le prohíbe a usted a radicar cualquier pedimento que usted desee en frente del juez que tiene el caso.
All right, thank you. Good luck.
Gracias, buena suerte.
Gilberto Molina Olivencia. No, just reset. I don't know how you want to write it.
Próxima comparecencia cuando sea ordenado.
Sir, good afternoon. Say your name.
Buenas tardes, caballero. Por favor, dígame su nombre. Gilberto Molina Olivencia.
Mr. Molina, you were arrested for domestic violence battery.
Señor, usted fue arrestado por un cargo de agresión violencia doméstica.
There is probable cause.
Existen indicios razonables.
And PTR, any history?
Antecedente penal, Departamento de Libertad Provisional.
Yes, he has history dating back to 2008 for a cocaine sale, violation of probation, DUI, and also a failure to appear in 2017.
Comenzando en el año 2008, tiene un cargo de venta de cocaína, incumplimiento de libertad vigilada, conducir bajo los efectos y un cargo de falta de comparecencia en el 2017.
Bond will be set at $1,000 with pretrial release.
La fianza será programada en $1,000 con condiciones de libertad provisional.
No contact with listed victim.
No puede tener trato con la víctima indicada.
No return to the address of the victim.
No puede regresar a la dirección donde se encuentra la víctima.
No weapons or firearms.
No puede portar armas de fuego o armas blancas.
Do not possess or consume any alcohol.
No puede poseer o ingerir alcohol.
Now, I will say I don't know if an assist order is needed.
Sí voy a decir que no sé si necesitamos una orden de ayuda.
Because it said that the parties no longer live together, but once lived together as a family.
Porque aquí indica que ya las partes no viven juntos, pero en un momento dado vivían juntos como familia.
So it looks like it looks like it was not his residence at the time of the incident.
Así es que parece que esa no fue la residencia de él en el momento de los acontecimientos.
If the facts end up being different, the defendant can file a motion for an assist order with the judge who has the case.
Si los hechos resultan diferentes, el acusado puede radicar un pedimento con el juez que tenga el caso para pedir una orden de ayuda.
Do you need a public defender, sir?
Caballero, ¿necesita la ayuda del defensor público? Yes.
PD will be appointed provisionally.
Se designa las oficinas del defensor público de manera provisional.
Next court date on demand.
Próxima comparecencia cuando sea ordenada.
Thank you.
Gracias.
That's all I had for Spanish.
Your Honor, could you kindly confirm the case number for this last defendant, please?
22 MM 1630.
Thank you, Your Honor. Nice to talk to you. Have a good afternoon.
Likewise, you too, thanks. Anitra Brown. Please state your name. Thank you. Ms. Brown, you were arrested on a warrant. This warrant is for scheme to defraud over $50,000, uttering forged check. Your bonds are $10,000, $5,000, and $5,000. So it's a total of $20,000 and no contact with the victims. Do you need a public defender?
I just want to say they did this case to me already in Barron County, Kentucky, for the same checks, and it was dismissed.
Okay, I don't know about that. I'm just reading to you the warrant that the judge here in the Ninth Circuit signed. Judge Calderon signed, and it's talking about May 6, 2022 in Osceola County, Florida.
Yeah, it was $50.
Well, I'm just telling you what the warrant said. You have the right to know why you were arrested. That's why you were arrested.
It's true.
Do you need a public defender?
Yeah, that's
PD will be appointed. Next court date will be on demand. Thank you. Nicholas Despau. Despiau, sorry. They had the letters mixed, or I got the letters mixed. Good afternoon, please say your name. Thank you. Sir, you were arrested on a warrant for violation of probation. Judge Karsten set your bond at 0. Do you want a public defender? PD appointed, next court date?
Next court date, July 27th, in court room 4F at 8:30 a.m.
July 27th. Thank you. Aaliyah Gould.
PD appointed.
Please state your name. Thank you. Ms. Gould, you were arrested on a warrant for violation of probation. Judge Nix Walker set your bond at 0. Do you need a public defender?
Yes.
PD will be appointed. Next court date?
Next court date, July 26th, in court room 5A at 9 a.m.
The 26th. So 6 days from now. Damian Hamilton.
PD approved.
Good afternoon. Please say your name. Thank you. Sir, you were arrested on a warrant and you have 2 counts, throwing a deadly missile and criminal mischief. Your bonds are $2,500 count 1, $500 count 2. Do you need a public defender?
Yes.
PD will be appointed provisionally. The warrant also contains no contact, no return, no weapons or firearms. Okay. And next court date will be on demand. Thank you. Eric Paris, for the record, meets criteria under VFOSC.
PD appointed.
Hello, can you please say your name?
Eric Paris.
Thank you. Mr. Paris, you were arrested on a warrant for violation of probation. The judge who signed the warrant set your bond at 0. Do you need a public defender? PD will be appointed. Next court date?
Next court date, July 26th, in court room 5A at 9 a.m.
July 26th. Thank you. Robert Roman Fuentes Jr.
Judge, the PDs have been appointed since July 2nd of last year.
Thank you. Please state your name. Thank you. Mr. Roman Fuentes, you were arrested for a capias for failure to appear. Judge Nix set your bond at 0. You've been previously appointed to the public defender, so they're already there representing you. Your next court date will be?
Next court date, September 21st, in court room 5A at 9 a.m.
Thank you. Aaron Sodom? Thank you. Please state your name.
And Seda.
Mr. Statham, you were arrested for a failure to appear capious. Judge Young set your bond at 0. You already have the public defender appointed to represent you. Your next court date will be?
Next court date will be August 8th in courtroom 5F at 8:45 a.m.
Thank you.
I wanted to ask if I could be considered for pretrial release.
You have to ask Judge Young. He's the judge who's assigned to your case.
What was the date for the court date?
August 8th. You're welcome. James Adrian.
PD has been appointed on both cases as of February 17th, 2020.
Thank you. Please state your name.
James Adrian.
Thank you. Mr. Adrian, you have 2 warrants for violation of probation. They're both set at 0 bond. You already have a public defender representing you. And for the record, he meets criteria under VFOSC. Your next court date will be?
Next court date for 2020 CF 402 and 2020 CF 394, August 12th in courtroom 4B at 2:30 p.m.
August 12th at 2:30 is your next court date. Thank you. Brandon Braxton.
PD appointed.
Please state your name. Thank you. Mr. Braxton, you were arrested for resisting merchant recovery, possession of paraphernalia, battery, and petty theft. Third is or subsequent offense. There is probable cause. PTR?
Yes, he has history in Florida dating back to October of 2021 for petty theft, loitering or prowling, disorderly intox, aggravated assault with a weapon, and resisting officer without violence. He also has history out of state in Virginia for shoplifting, obtaining money, false pretense, contributing to delinquency of a minor, abuse, neglect child, grand theft, drug possession, trespass, and violation of probation. And he also has a warrant currently out of state.
Are they going to extradite?
No extradition.
Okay. Bonds will be stayed. Do not return to that Wawa. Do not have any contact with the employee of the Wawa. The next court date will be?
On demand.
That means they'll let you know, sir. Thank you. Apple Costa.
PD appointed and Judge did Mr. Braxton want to speak?
Yeah, no, why? Because you said he qualified and he has no other means to.
Yes,
Hi, please say your name.
Apple Costa.
Thank you. Ms. Costa, you were arrested for possession of cocaine and possession of paraphernalia. There is probable cause. PTR?
She has history out of Florida dating back to 2014 with petty theft, drug possession, battery on a pregnant person, kidnap, false imprisonment, grand theft. She also has history out of Texas for theft of service, Missouri, fugitive from out of state, North Carolina for assault, Illinois for possession of controlled substance, retail theft.
I never had a charge on a pregnant woman.
Okay, I'll disregard that one.
Okay.
She doesn't qualify for any PTR supervision because of her out-of-state legal constraints.
Correct.
And is it a warrant that they'll extradite on?
I don't have no warrant.
I don't have that information. I do see that she had the retail theft charge out of Illinois back in February of 2022, but we were unable to see if the case is still open.
Gotcha.
So we didn't want
The
to.
case is closed because I was just now a week ago, I just now came out of here.
Okay.
And my public defender called up Chicago, Illinois, and they said I don't have no case over there.
All right, so your bond is stayed at $1,000 in count 1 and $100 in count 2. Do not possess or consume any illegal drugs. Do you need a public defender to represent you here?
Yeah, because I don't, Your Honor, I don't have no one down here to put my bond.
PD appointed. Okay.
Your Honor, the state is also requesting no return to the 2703 West Vine Street Avenue.
That's fine. No return to the address 2703 West Vine Street. And your next court date will be?
On demand.
On demand. Thank you. Felix Dumas.
PD appointed.
Ms. Costa, go sit down. I need Felix Dumas. I'm sorry, I'm not being impatient, I just have a limited view. Is there a Felix Dumas in there? No problem. Like I said, I can only see very few rows, so I can't see if people are moving on the other side of the camera. Good afternoon, please say your name. Thank you. Mr. Dumas, you have two booking reports here. You have the first one that you were arrested for burglary of an unoccupied vehicle, criminal mischief, and petty theft. There's probable cause for that. And then a second report that says credit card fraud, possession of stolen credit cards, and resisting without violence, and there's probable cause for that. It looks like you also have an open case, 22 MM 1547, for theft that you were out on PTR. Let me ask pretrial release if there's anything else she has.
Yes, he has history dating back to 1995, which consists of 71 felonies. and
71 felonies?
And 30 misdemeanors.
Okay.
They consist of burglary, burglary tools possessions, shoplifting, petty theft, marijuana possession, BOPs, several FTAs, driving while license suspended, revoked, resisting officer, synthetic narcotic cell, hallucinogen cell, burglary, burglary tools possessed. He has an FTA in 2019, resisting officer without violence, several burglary and petty theft charges, cocaine possessed, public order crimes. And the last arrest was in July for the fraud that he's out on PTR on.
So the burglary will remain 35, criminal mischief will be 100, petty theft will be 100, all with no contact, no return. The fraud will be 1,000, the stolen credit card will be 150, the resisting will be 100, no contact, no return. And then 22 MM 1547 PTR will be revoked and set at $500, no return to Home Depot. Mr. Dumas, do you want the public defender to represent you on all of this? PD will be appointed. Excuse me? It says, it does say, burglary of an unarmed vehicle. I mean, unoccupied vehicle while unarmed. Yeah, they did. Maybe they didn't tell you, or maybe you didn't hear it, but that's why you come to me, so that I can tell you, that way you know why you're in custody. I don't know if the state's gonna file on it, but that's one of the reasons why they've got you in custody. Okay, so, on demand is your next court date. Thank you.
And what was the bond on the burglary charge?
That one stayed, and then everything went either 150 or 100, depending on the category.
Thank you.
Sophia Fernandez Zabal. Please state your name.
Sophia Fernandez Zabal.
Thank you. Ma'am, you were arrested for domestic violence battery. There is probable cause. PTR, any history?
She has no prior arrests.
She qualifies for PTR with bond, correct?
Correct.
All right. Ms. Fernandez, what I read in here, and based on the fact that you score low on the risk assessment, your bond is $500. With pretrial release, you can't have any contact with the listed victim, Anthony. You can't go back to the Barclay Lane address. You can go one time with the law enforcement to pick up your personal things if you want to, like your clothes and whatnot, but otherwise you have to find someplace else to stay until this case gets resolved. Don't possess any weapons or firearms. Do you need a public defender?
No, yes.
PD will be appointed provisionally. Your next court date will be on demand. And then Kevin Pate. That's all, ma'am.
PD appointed.
Good afternoon. Please say your name. Thank you. So, Mr. Pate, you were arrested on domestic violence battery. I've read this affidavit, and there is probable cause. PTR, any other history?
Yes, he has history dating back to 1991, which consists of 24 felonies and 10 misdemeanors. They are also burglary, grand theft, aggravated battery, aggravated assault with a weapon, DUI, resisting officer without violence, cocaine possessed, habitual offender for driving while license suspended, obstructing justice, battery domestic violence, which she does not appear to be the same victim, and flee and elude police.
Thank you. Sir, based on what I've read and what I've heard, your bond is going to be set at $2,500. You are to have no contact whatsoever with the listed victim, Alicia. You are not to return to the scene of the incident, which I believe is 2406 Parsons Pond Circle. Well, for now, you're not going to be able to go back there while she's there. If she's not living there, then you can file a motion to get back in. But this indicates that she was also residing there, so. Okay, well, for now, you can't go back until she leaves. You may not possess any weapons or firearms. Do you need a public defender? Sure. It's up to the state attorney to decide whether or not they want to press charges. An uncooperative victim is something we see a lot, but that doesn't mean the state can't still try to go forward and prove what they can prove through other witnesses. So it's going to be up to them to look at it and see what they think they can prove. I hope so. Next court date on demand. Thank you. Did I miss anybody from the jail, Mr. Rosa? Thank you. See you all tomorrow. Have a good one.
Can we do Derek Spence?